of today's list, that is item number 116, 116, sorry, 116 for upgradation. But in this matter, the petitioner is a senior citizen and suffering a lot. Initially, the matter was appearing before the Honorable Justice Supratim Bhattacharya when a day was fixed for hearing, but due to change of determination,
I am releasing the matter.
yes, my lord.
Should I release it?
Today?
Should I release it?
No, I am paying for upgradation.
Have you served?
If it is upgraded, I will serve
No, you
immediately.
serve and come. No mentioning without service. You serve and come. Yes.
Lordship, may I be permitted to mention one matter?
Served.
No.
Serve and come. Yes. Call the list. Let's see. Let's see. Bring your friend. Then the second up. We will see to it.
Item number 1, we got kindly fix it up next week. We got.
It is hard in part yesterday. Who was appearing?
What happened, my lord? My junior is there. His father, was the advocate, and he is not coming to. Neither he nor I have any at that motion stage. We moved, no contact with the client at all. That's the whole difficulty. After so many, the matter has come up after so many years, we could not establish any kind of contact with the client, and he gives a 1 week's time, at least.
On the prayer of Mr. Shonak Bhattacharya, let the matter be listed on 23rd of August.
Yes.
Under the heading for orders.
It has come up after so
Yes.
many years. We could not.
No, it was running in the list.
Yes,
You
yes,
did not
yes.
notice. Yes.
I'm for the petition.
Five minutes.
Yes, madam. Plaintiff the petitioner before your lordship. Plaintiff filed a suit for specific performance of contract.
Yes.
In that case, the defendant appellant, opposite party appeared and filed written statement.
This
and,
is not the.
Controverting the material that the agreement was not done between the parties. And
This is the matter we heard yesterday.
yes, my lord.
Yes.
And in that case, my lord, the opposite party filed an application under section 35 of the Indian Stamp Act for impound the document. My lord.
Document. Yes.
Yes, my lord. And the learned trial court holds that it should be impounded as under item number 5D, schedule 1A, as per entry number 23 of the schedule 1 of Indian Stamp Act. My lord. So, my lord, I am kindly. What is 5D? 5D, if relating to sale of lease cum sale of immovable property, the same duty as conveyance for market value, under article 23. And but my question is that here, what is conveyancing?
What is your agreement? Tell me first.
Yeah, agreement for the handing over the flats. I am a tenant.
No, you are a tenant.
Yes.
You surrendered your tenancy.
Tenancy.
There could be certain agreement that upon construction, possession will be given
handed
back to you. That is one aspect.
One aspect.
If it is not done, there is no need to file suit for specific performance of contract. If you say that you intend to acquire the ownership of the flat, and to that effect there was an agreement, then the agreement should be properly stamped.
Yes, madam. And that agreement should be properly stamped.
Indicate your compartment.
Yes, madam. That madam, kindly come to section 2 of subsection 10. What is conveyance?
Yes.
Conveyance include a conveyance on sale and everything instrument by which property,
whether movable or immovable,
Hmm,
is transferred,
yes,
and my property is not transferred yet, my lord.
you have entered into an agreement.
Yes, my lord.
So
But
the stamp duty required to be paid at the time of conveyance is to be paid on the agreement.
yeah, on that point, my lord, I am
Read the provision, forget about judgment. First,
Yes.
read the statute.
yes, my lord. The statute
All the
said
time, don't
is
bank up a
transferred,
judgment.
my lord, and the statute is, my lord, kindly 5D.
Yes,
If relating to sale, lease comes sale
yes.
of immovable
So
property.
your case is a case of sale. You want to purchase.
But the consideration is that my possession, free for possession is handed over to the
Then it cannot be
Landlord.
sale.
no, my lord.
So your agreement will go for sure.
But it will be handed over to me. my
It
lord.
will never be handed over to you.
Yes, my lord. The question is that the yes,
Do you have Transfer of Property Act?
no, it doesn't.
You don't have. I Adito, what is sale? What is sale? Use your mobile or take my Transfer of Property Act. Then go through section 54. আর দুটোই দিন স্ট্যাম্প একটাও আমাকে একটু দিন দিন তো নাকি বইটা take this book, sir.
Yes, my lord. The sale under section 54 of the Transfer of
Yes.
Property Act that refers to the transfer of immovable property in exchange for a price or money consideration. Contract for sale can be defined
What
as
are you-
term of settlement.
What are you reading? Read the statute. Take this book. Take this book.
This sale how made, and such transfer in case of tangible immovable property of the value on one hand rupees 100 rupees and upward,
Hmm.
or in case of a reservation or other intangible things can be made only by a registered instrument,
Yes.
and
That is called conveyance. Yes.
and a contract for sale of immovable property is a contract that a sale of such property shall take place on terms settled between the parties. It does not of itself create any interest in or charge on such
What are
property.
you reading, sir?
It is contract for sale one.
Why don't you read section 54?
Yes, my lord.
Read the section.
Section of sale
Don't
defined, my
read.
lord.
Yes.
Sale is a transfer of ownership in exchange for a price paid or promised or part paid and part
So
promised.
there has to have some price.
Yes, ma'am.
There cannot be any sale for free.
I am not.
That is gift.
Yes, ma'am.
Your agreement is for sale
Yes, ma'am.
and there is no consideration money.
I am not disputing the sale. It should be
It
stamped.
does it carry any sense? First you tell me.
Yes.
How it could be an agreement for sale? I need your assistance on that.
Because the consideration has fixed that I should hand over the free access on the
There could be gift. There could be gift.
and it was agreed between the parties that the deed of conveyance made at the time of final settlement. If there is any
What
excess-
would be the sale price?
if there is something excess between that I should pay, then the
That is vague. That agreement cannot be enforced. So there is no reason to interfere with
I
the
am
order.
not
impute.
on that point that I am relying upon that on the basis of that it should be stamped. But what is the value of this stamp? It should whether it should be rupees 10 or it should be
No, why it should be 10?
yes, my lord.
It should be the value of the conveyance.
Yes, my lord. And in that respect, my lord, I am relying upon only one judgment. Kindly, my lord.
What is the fact?
Yes, ma'am. This is same, my lord.
No, this is same will not do. You tell me the fact of the
Fact is
case
that-
decided and the
Okay,
case at hand, how it is in perimetry.
Yes, sir.
Otherwise, I will not
Uh,
look into the decision.
In that case, my lord, it is petitioner filed and suit for specific performance of contract.
Yes,
Where is produced the deed of agreement for sale,
yes.
and when it was taken as the evidence, the respondent took a plea that it should be stamped,
Hmm.
and learned trial court decided that it should be stamped.
Hmm.
Thereafter, the appeal was preferred, a revision was preferred before this high court,
Hmm.
and the judgment was reversed.
Hmm.
Thereafter, the respondent filed an SLP before the Supreme Court,
Hmm.
where the Supreme Court observed that when there is a sale,
Hmm.
but the transfer was not made,
Hmm.
in that case, the minimum stamp.
So,
rupees
so
3
according to you, this provision has been declared ultra vires.
No, well,
Then
it is
this fact must be something different.
uh, Supreme Court. 2013 AIR SCW 582. Well, relevant paragraph is
Yes, tell me relevant paragraph.
910, from 910. May I as stated earlier, my lord, the
Hmm.
plaintiff filed a suit for specific performance of contract, and
Hmm.
in their case,
Hmm.
it is found on the agreement to sell executed on 27 December 2000. The agreement to sell acknowledged payment on the part and consideration money further gives the actual physical possession.
Hmm.
That how physical possession was given, but the conveyancing was not done by the physical possession to the purchaser by the seller. Though the defendant dispute, but in my opinion, the determination of question of admissibility of the document, it is the rhetorical recital therein which shall be
Hmm.
whether the possession in fact was given or not in the terms of agreement to sell is a question of the fact which requires adjudication.
Hmm.
The definition was thereafter, my lord, the definition in the act, unless there is something repugnant in the subject or context, the definition conveyancing includes conveyancing on sale every instrument by which property, whether movable or immovable, is transferred under divorce and which is not otherwise specifically provided by the Schedule 1. Number 10, paragraph number 10. From the plain reading of the aforesaid provision, it is evident that an instrument by which movable or immovable property is transferred comes within expression of conveyance. In the present case, an immovable property is transferred on payment of part of the consideration and handing over the possession to the property. It is relevant here to state that the Indian Stamps Act Amendment Act 1990, few articles include such as Article 23 of Schedule 1A has been substituted, and explanation has been given in Article 23. Thereafter, the follows, my lord, for the purpose of this article, where in the case of agreement to sell immovable property, the possession of any immovable property is transferred to the purchaser before execution or after execution of such agreement without executing the conveyance in respect thereof, then such agreement to sell shall be deemed to be a conveyance and stamp duty thereon shall be leviable accordingly. If the possession is handed over, then the section will play.
Have you read the entire judgment? Come to paragraph 12.
Yes, sir.
Come to paragraph 12 and read the judgment.
Yes, sir. From the plain reading of the aforesaid provision,
Yes.
it is evident that an authority to receive evidence such,
Yes.
yes, madam, shall not admit any instrument unless it is duly stamped.
Yes.
An instrument not duly stamped shall be admitted in evidence on payment of duty. which the same is chargeable, or in the case of an instrument insufficiently stamped,
Hmm.
of the amount required to be make up such duty together with penalty.
Hmm.
As we have observed earlier, the deed of agreement having been sufficiently stamped.
Having been insufficiently stamped.
Yes, sir.
Yes, then,
Insufficiently stamped means
yes,
insufficiently stamped. The same was inadmissible in evidence.
what does it mean?
It does not accepted as evidence, my lord. But in that case, my lord, the court
You are
observed.
relying on this judgment.
Yes, my lord. On where
It is just squarely against your
no, my lord.
submission.
When the possession is handed over, the Supreme Court orders in the next paragraph. When the possession is handed over,
Yes, yes, you did.
it is yes, paragraph number 21, my lord. It is not in dispute that the possession of the property had been delivered in favor of the appellant. He has thus been exercising some right in over the land in question. We are not concerned with the enforcement of the said agreement, although the same was not registered, but registration of the document has nothing to do with the validity of thereof as the provided under section Provision of Registration Act 1908. We have noticed thereof the section 33 of the Act first is statutory obligations all the authorities to impound a document. The court, being an authority to receive a document in evidence, is bound to give effect thereto. The unregistered deed of sale was an instrument which required payment of stamp duty applicable to a deed of conveyance. Adequate stamp duty admittedly was not paid. The court has therefore empowered to pass an order in terms of section 35 of the Act. To put the record straight or correctness the impugned judgment, Lakshmi Narayan versus others versus Om Prakash and others, 2008, volume 2 MPLJ, page 416, came up for consideration before revision bench of this High Court, of the High Court itself in repetition number such and such through legal representatives Srimati such and such, and same has been overruled by judgment dated January 22, 2010. The High Court observed as follows: a document would be admissible on the basis of recited made in the document and not on basis of the pleadings. It is not even. It would then after page paragraph 13, it would put record statement. A document would be admissible on basis of the reticular documents, not on basis of the pleading. Recital on not basis of the pleading raised by the parties in the matter of Lakshmi Narayan Supra, the learned single judge, with due respect to his authority, we done. We don't think that he did not look into the legal position, but it appears that he was simply swayed away by the argument that the defendant was denying the delivery of possession. The endorsement in the document lost all its effect and efficiency. The question has been decided whether the proper stamp has.
Yes, yes, you read. I have read the judgment. You read. Should I indicate the paragraph? Come to paragraph 16. Then move to paragraph 2. First you read paragraph 16, then come back to paragraph 2.
The defendant denied the agreement of sale.
Yes, you did. Have you read it?
Yes, my lord.
So order of the High Court was reversed
Yes.
and order of learned trial court was restored. What was the order of learned trial court?
But the proposition.
Again, no.
Yes, my lord, that it should be informed. But the proposition, if the transfer property was
Now
not.
look, since there is no whisper as to the consideration money, you may not be required to affix stamp, but at the end of the day, your suit will go. I shall indicate that. I shall set aside the order of learned trial court, but it will never be considered as agreement for sale. Agreed?
No.
No. Then
But. the
Then go
provision
and
will
pay the stamp duty. Then I am not going to interfere with the order.
No, but the position of the.
There is
position
nothing, no part if nothing. Law is very clear. You need to pay stamp duty.
Yes, my lord.
In your case, what is favorable is that there is no indication as to the consideration money. So you cannot pay stamp duty as laid down under section 35 or whatever. To that extent, I shall reverse the order of learned trial court, indicating that it was never be an agreement for sale. Sale, in absence of any consideration, cannot be said to be a sale per se under section 54.
But the-
Choice is yours. Don't waste my time. Choice is yours. I will move to the second matter.
Then, well, I have taken for 5 minutes.
You have to take instruction. What instruction?
The client is.
It will be a simple case of surrender of tenancy,
Yes,
rebuilding of property, and possession would be,
but the opposite. party
you
has-
will never acquire ownership.
But the opposite party in their written statement denying that there is a sale of agreement.
There, it is not an agreement for sale.
No, they are denying the instrument also.
That I don't know. That is the learned trial court to decide.
And the position still not handed over.
This is not an agreement for sale.
Yes, my lord, without any
You
consideration.
cannot have title over the property. But yes, as tenant, you have surrendered for building, rebuilding, it will be delivered to you. But you will remain tenant. There is no doubt about it. Choice is yours. Decide, come back after 5 minutes, yes or no.
Okay.
Dakun. Call the next matter. Ready?
I have fully ready. Now,
Yes.
well, as my lord directed,
Yes.
Well,
application.
directed yesterday,
Yes.
I have typed the gist of the fact. Well, if your lordship so desire, your lordship may accept it or not. Well, let me place the case.
Yes.
Well,
Have you given the copy to your?
Just now I have received the
Yes.
copy, but I am not on this, whatever my letter.
Very well.
And I
no,
reserve my
it is
right.
for me.
Yes, yes.
This is only for me. I have handed over to my lord.
Yes,
and also
yes, you
my
carry
lord
on,
friend,
carry
Yes,
So
no
that
issue, no
what
issue.
I do not submit
carry
others.
Enough.
Because a plot of land was there,
Hmm.
namely 470,
Hmm.
having an area of 30 decimals
Hmm.
or 0.30 acres.
Hmm.
Well, that land was transferred and transferred. I am coming to the suit. In 1996,
Hmm.
one Jagannath Jana,
Hmm.
Bhanucharan Jana Das,
Hmm.
the appellant hearing, and Siddheshwar Das,
Hmm.
as plaintiff filed a suit
Hmm.
being titled suit number 221 of 1996
Hmm.
for declaration of his title and
Hmm.
permanent injunction
against Jagannath Jana and Rabindranath Jana as defendants therein.
Hmm.
The suit was filed before the learned civil judge junior division first court contact.
Yes.
And in 1997, the respondents herein,
Hmm.
namely Rabindranath Jana
Hmm.
and Rabindranath Jana and Miller Kalpana Jana, filed a title suit being 156 of 1997 for petition before the learned civil judge, senior division first court Kontai against Bhanucharan Das and Siddheshwar Das and Jagannath Jana.
So did you purchase the undivided share of any of the co-owners?
Here, my lord. Let
We
me-
are
let-
the
Don't get excited. Let him. Yes.
You also can you let me press the case? I am coming. What is our case in the suit? Our case is that plot number 470 is the original plot, which belong to one Murari Das and Shashi Bhushan Das.
Hmm.
Well, I have stated in the case of the plaintiff.
Hmm.
Their names were recorded in the RSROR.
Hmm.
And subsequently, on 8th of April 1942, they transferred
Hmm.
18.5 decimals of land on the eastern portion of the plot in favor of one Baroda Sundari Jana, who is the mother of Rabindranath Jana and Jagannath Jana. And the said land was, not your lordship kindly, excuse me, not Bata plot, only plot number.
Hmm.
I have written as Bata plot, that is
Okay.
the mistake.
Okay.
Plot number. Plot number 470 in their name.
Hmm.
But in the name of
In her
Baroda
name.
Baroda Sundari. Now, after such transfer,
Hmm.
out of 30, as they transferred 18.5, remaining 11.5 is there.
Hmm.
11.5 শতক land is there.
Hmm.
And in 1949 BS, that Shashi Bhushan died.
Hmm.
Shashi Bhushan died when he was a bachelor. He did not marry, so there are no heirs of him. So that property, the share of Shashi Bhushan
Hmm.
in respect of 11.5 decimals of land
Hmm.
devolved upon his brother Murari Mohan Das.
Hmm.
And subsequently Murari died. Murari having died, his share devolved upon Bhanucharan Das and Siddheshwar Das. Now my client is Bhanucharan.
Who
Here
are
the-
they? Who are they? Are they the sons of Murari?
Yes, they are the sons of Murari.
Okay.
They recorded their names in the RS records of
Hmm.
and paying. And in their case is in the court below that in 1403 BS, the defendants of the case threatened them for dispossession.
Hmm.
And on the plea that they are the owner of 20 decimals and you are the owner of 10 decimals. So you cannot enjoy this land. Well, so my lord, I also confirm as to whether so far their statement is correct. I can learn from the map that in the map, my lord, that plot number 470 has been shown as with an area of 20 decimals. And my lord, the Pata plot number 470 of 1049 is shown 10 decimals of instead of 11.5. Well, here I have
No. Shashi Bhushan, according to you, died bachelor.
bachelor.
But here on the second page,
They
defense
are
says-
saying, no, their dispute is there. They are saying, no, he did not die the bachelor. He died leaving behind a daughter, Tilottama.
Hmm,
I have faced, but I have not suppressed anything.
no,
Their case is, Shootland, there similarly is there up to Miller, Murari and Shashi Bhushan is there.
hmm,
They are saying Murari, no, Shashi Bhushan died,
hmm,
leaving behind him Tilottama, his only daughter.
hmm,
So Tilottama inherited the property
Hmm.
left by Shashi Bhushan.
hmm,
And on the death of Tilottama, Subimal, Ganesh, Nonibala, and Podibala inherited the property. And they were put in joint possession
hmm,
with Murari.
hmm,
On that ground, and the appellant sharing on demand refused to have the property partition. They filed the partition suit in 1997.
hmm.
That dispute is, we are saying Shashi Bhushan got no heirs. They are saying got one daughter.
Hmm.
They are saying they have purchased from all their heirs, sometimes in 1997, from the heirs of Tilottama. It is their case. On 28th of July 1997, they have purchased. Sending all these, Miller, the partition suit, and Miller, the dispute over that dispute, and the title suit was there. আস্তে আস্তে হুজুর দেখছে দেখলো
Manucharan was a party to the suit for partition.
Yes,
Manucharan was a party.
party. Well, I have mentioned who has been made party in the partition suit. Miller partition suit against Miller Bhanucharan,
Hmm.
Siddheshwar and Jagannath in first page. I have mentioned.
What is the number of the second appeal?
Second appeal.
Second appeal challenging the preliminary decree.
That is below that is number as below TA.
No,
second
19 of 1999.
19
May
of-
I-
No. Second appeal is
Oh, 31.
31.
31.
31 against 38.
Yes,
19.
31. Fine. In this appeal, you want to implead the legal heirs of Bhanu.
Bhanuchar.
Yes,
And in both the appeal, Bhanu is the appellant.
Bhanu is appellant, but in
First
the,
of all, your lordship is taking the 31.
yes,
Let us confine to that.
enough. Suit for partition. Suit
Yes.
for partition.
My lord.
You have admitted Bhanu as co-sharer. You have filed the suit against Bhanu.
Yes.
So admitting Bhanu as co-sharer, you cannot deny the entry of the legal heirs of Bhanu on the ground of abatement, etc. in a suit for partition. Right?
That is
That is correct.
one aspect. That is
No,
Definitely that is
let
correct.
let us go one
from
by
the
one.
order of court.
Let us go one by one. I can't
My
spend
lord, my lord.
time required for second appeal hearing for a substitution application. So what is your objection to the substitution petition so far SA 31 is concerned?
So far, section 5 application is concerned.
Yes.
I am on that point only. Kindly appreciate.
Even if they don't prefer application under order 22,
My lord.
they are entitled to get implemented under order 1 rule 10. This is a suit for partition. You cannot maintain the suit leaving aside the co-owners. They have now become co-owners, having stepped into the shoes of Bhanucharan. I am talking about the suit for partition here.
Partition, that is our
Yes.
suit. That is
So
the
there should be no
respondent's suit is
objection.
concerned. Now,
Take down.
but only one thing, my lord, kindly appreciate. Your lordship will
Not
kindly
in the
appreciate-
suit for partition. On the second suit, I shall hear you.
No,
Yes.
because that suit has been decreed and their suit has already been disputed,
So,
your lordship.
Wait,
Kindly
as of
appreciate
now,
this.
I am on second appeal in partition suit. Yes, take down.
Because 900, after 901
This is
days
a suit
delay, they
for
have come in.
partition. Even they, God, there is judgment of this honorable court also. In division bench judgment in CWN. Order 1 rule 10 is also applicable.
Then only one point singly, kindly appreciate before passing any judgment as your lord.
Yes, have
Only-
your
only
say.
One, only
Yes,
one
yes.
aspect. Section 5 applicable, kindly be seen. May kindly be seen. Because when they have filed the section 5 application, they have admitted and they have stated clearly therein that the delay is for 901 days. Now, after that, when we have filed the affidavit in opposition regarding that application, then and there, they have filed another supplementary affidavit, and there they want to say, that no,
They are seeking concession.
concession, but without
Very
any valid grounds. My kindly appreciate
It's
this.
much ado about nothing. So far partition suit is concerned. You are Mr. Sinha.
Yes,
Yes. Heard Mr. Patro and Mr.
before
Sinha,
passing,
learned
another-
counsel
another submission-
representing.
Another submission is also there.
I am
Represent,
Mr. Manna.
hold on. I will listen to your submission. This is a suit for partition. Yes.
Well, I am Mr.
Representing
Manna,
the
assisted by Mr. Patra.
Okay, you are Mr. Manna. Okay. And নামগুলো ঠিক করে লিখো. Stop. It is contended that Bhanucharan Das, one of the defendants in a suit for partition, died on 17th of September 2019, died intestate on 17th of September 2019, leaving behind him surviving his widow. How many sons? I. Widow, Srimati Bashanti Das, and 8 sons and daughters. Stop. Who have stepped into the shoes of their predecessor in interest, Bhanucharan Das, and have acquired the status of co-owners in respect of the property in suit for partition. Stop. According to Mr. Sinha, there is a delay of
901 days.
901 days, which have not been explained in a
Not at all.
yes, which have not been explained in the application under section 5 of Limitation Act. Stop. Be that as it may, since the legal heirs of Bhanucharan Das, having stepped into the shoes of their predecessor in interest, acquired the status of co-owners, they are necessary parties for effective adjudication of the appeal arising out of the decree passed in preliminary form in a suit for partition.
My lord.
Stop. Even if
And liberty is also given to both the
Yes,
parties
yes,
to
yes.
amicable for
Even
practicable
if-
partition.
they can be implemented under Order 1, Rule 10 of the Code of Civil Procedure in a suit for partition. Stop. Therefore, I am inclined to allow the application for substitution thus can 3 and what is the other can?
My lord,
Can 2 and can 3.
Can 3 is for substitution.
And can 2 for limitation. Yes, can 2 and 3 are disposed of.
Can 3 section 5,
Can 2 and 3 are disposed of. Have you filed Wakalatnama? Who will represent the substituted respondents or appellants? Have you filed order 22 rule 3?
No, without filing that he
No.
cannot move.
Why you are hesitating? Now give me the second one. There it will be very difficult for you. Now you have to explain every day's delay. This is not your suit for partition.
No, it is a suit for declaration.
Yes, now you explain.
Your lordship has seen or everything.
I have not seen anything.
No,
It was a
how the appeal has come. Not on the section 5. About the appeal, your lordship has heard and seen.
yes.
Well, now I am to.
I am not hearing the second appeal. I am disposing
Your
of
lordship is
substitution application.
hearing the section 5
Yes,
in essay 32 of 17.
yes,
If I am correct. Because
Yes.
your lordship knows better than me. In 1919, there was a pandemic throughout the world. People could not move from here to there. Though it was not declared by the government as a pandemic and closed everything. In fact, from 1919, pandemic was started. And ultimately in 20, government declared the pandemic and closed the movement of the people at large. And during that period, some limitations arose in some cases. But the matter went up to the Supreme Court. As
no,
to-
matter didn't went up to Supreme Court, it was suo motu order.
No,
It was suo motu order.
Suo motu. Not matter. Wait a minute, if question arose before the Supreme
Honorable Apex Court suo motu passed the direction.
Court direction,
Yes,
that the delay will be condoned, the period will be excluded from 15th of March 20 to 28th of February 22. I don't know whether I have handed over a copy or not. Your lordship may produce the copy. The last paragraph, the concluding paragraph,
yes.
the concluding paragraph, your lordship can ignore the marking.
Hmm.
So, my lord, this period has been directed to be excluded from the limitation. Then
Hmm.
in that event, as the death was, my lord, occurred on, my lord, 17th of September 1990, the limitation should have
1990,
19,
yes.
limitation should have started on and from 17th of January 2020. It will be within time. Then, my lord, from January to March 15 of 20, it will be, my lord, 58 days.
Hmm.
And in, my lord, then, my lord, in, my lord, thereafter in
You
April,
deduct,
I have filed in April.
you deduct straight away 150 days. 90 plus 60.
No. 9 days, yes, sir. And that period will be excluded. Then, my lord, delay will be only for 66 days. According to my calculation, delay will be only, my lord,
Very well.
56 days. Because I filed on 8th of March 2020.
Yes,
may I please your lordship?
but yes. How have you explained your 66?
I have
delay?
explained, my lord,
Hmm.
your lordship can
Which
come.
paragraph?
I have stated
Hmm.
that,
Is there?
Are bhai, I'm
না না আপনি
the-
আমি নিজেকে আপনি আপনাদের বলছেন
I have stated
Hmm.
that we were not conversant with the, or got any knowledge about the pendency of the appeal.
You were
We
not
don't
aware
have
of.
any knowledge about the pendency of the appeal. and only on, only on, only, I've taken notes here. In the earlier.
Now, let me pollute the situation. Wait for a while. Yes. Yes, sir. Now, allowing criminal. Yes. Allowing criminality. Yes. Tell me.
Well, sorry, tomorrow your lordship, I gather, has a division bench which just said. That is what the list today says. List
not
of information, sir. That is why I have come.
I am not aware. I have not yet.
Well, please seize, Malak. Seize the cost item, Malak.
Wait, but
That is Malak. কালকে ফ্রাইডেতে হাফ বেলা নাই না ওই জন্য জানি মানে one is with Justice Kapoor and the next is with আজকে লিস্টটা দাও না অরিজিনাল সাইডে লিস্টটা দাও
original side matter.
হ্যাঁ অরিজিনাল সাইডে আছে
Anyway,
so Malak,
It is
first
a
is
coup.
with Justice Kapoor there is one but the
At-
time has not been given. That is why Malak, because that lady, that matter, Malak, that was
it will not before
two.
not before two, for sure. So we shall take up the matter
Well,
in the
it's all
morning.
right.
Yes. Thank you.
Great.
Yes, sir. Sorry.
But
I have stated in paragraph,
thank you.
I have stated in paragraph 13,
Hmm.
the date. That is 17th of September 2019.
Yes.
And then, my lord, in paragraph 16, I have stated how I came to know
Hmm.
at page 12.
Yes. Paragraph 12.
Paragraph 12, paragraph 16, sorry, paragraph 16, page 12, and paragraph 13 at page 10 of Can 2 of 2022 in essay 32.
Yes. Yes.
And I also explained, why I put delay over there in paragraph 17.
Yes. দুটোর পরে হবে। Yes,
May I
sir.
please, your lordship?
Yes.
It is an admitted fact that the original appellant
Hmm.
died on 17/9/2019.
Hmm.
So the statutory period for substitution is 90 days and that ends on 16 December 2019.
Hmm.
So thereafter, from 17 December 2019, limitation started,
Hmm.
subject to correction of my learned senior friend for the other side. This is the first thing. This is my first fold of submission. That date of death was 17th September
On
2019.
17th of December 2019, suit
Lim-
was abated or appeal was abated. Yes.
This is one part of submission. My
Hmm.
second full submission would be that so far they have stated that they are a strict village and they are not known about these things. My lord, kindly come to their application of section 5, para 14. Para 14 or para 14 or 32, na? 30. One second, my lord. Is section 32, na?
Yes.
Page 13. Or previous page 12, para 17. If I may read it loudly, subject to correction. That the appellant stated herein that both the sons of the deceased are migrants, laborers, and rustic villagers. Moreover, 20P stroke appellant B stroke applicant B has lost his physical ability and capacity for hard works due to fallen from iron structures 10 years ago, and due to the aforesaid incident, at present he has been suffering from chronic spondylitis disease since 2012, and he is a regular patient under treatment of the SSKM hospital. Now, here is the vital thing, what they have admitted. Although once in the year of 2016, he had affirmed an affidavit of the application in connection of the second appeal as per authorization of his father. It means that they have full knowledge of this, all these suits and appeals and other things. So they cannot deny, they cannot go beyond from their admission. They cannot go back from their admission, whatever they have categorically stated. And I'm apprehending on these points that with full knowledge, having full knowledge, they delayed knowingly. They delayed knowingly. That is suffice that they have in 2016. This applicant, the present, one of the present applicant.
Kindly go through the next sentence.
1 second, let me. So if somebody knows the thing, and if see, then my lord, kindly appreciate my respectful submission that then they are not known, or their father never said about this regarding all the status of these appeals, or regarding the cases of the court cases. That is particularly knowingly, ill-motivatedly, they have stated a false statement before this honorable court on affidavit. And now another one. My second submission would be, my learned senior friend for the other side has cited that suo motu case of Honorable Supreme Court for the relaxation of the limitation time. So I am reading it loudly, the main portion. In case would have expired during the period between 15th March 2020 till 20th February 2022. The limitation shall be governed or shall be continued after 1/3/22 from after 1/3/2022 or 1st March 2022 and 90 days thereon. But in this specific instant appeal, the original appellant died in the month of September 2019, where the limit, what should I say? The statutory period for substituting the legal heirs of the deceased was over up on 16th December 2019. So in this case, the limitation does not come in within the purview of 15th March to 20th February 22, the COVID situation. Actually, in the month from the 17th December 2019, from that particular date, the limitation started. That limitation started, and COVID situation come up in the March, in the middle of the March of 2020.
has not started.
Hmm.
No, we have suffered, everybody has suffered from the March of. প্রথম লকডাউন তো তখনই হলো, তারপরে তো আমাদের লকডাউন
মার্চ করতে রেস্ট্রিক্টেড ছিল।
কিছুই হয়নি, আমাদের মার্চ অব্দি আমরা সবাই কোট করেছি।
Government
May I kindly appreciate, my lord.
Hmm.
The relaxation was if the limitation period or the statutory period comes within the period of 15th March 2020, then they have, then I have no case. Then I have certainly no case at all. But in this specific instant appeal, limitation has started from the month of December 2019, my lord, kindly appreciate this. So my first respectful submission would be that first of all, knowingly, they have misled the court that they did not know anything. And for the first time in the March of 2022, they have come to know that of certain pending cases before this honorable court. That is untrue, that is incorrect. Because they have stated in their section 5 application that in the year of 2016, that one of these applicant has filed an affidavit with the authorization from her deceased father, that is Bhanu Chandra Das. So if this honorable court may kindly allow me to ask a question to myself, then I want to put a question to myself that how come a person who knows it since 2016 can state it as on affidavit before this honorable court that nobody knows about all these things, and after on the February 2022, I have came to know. And so far the limitation case is concerned, limitation already been started from.
How you will be prejudiced?
And the
If
third
this
submission
appeal
would be-
goes, no,
And third submission.
not
my lord.
required. How you will be prejudiced? If this appeal goes, the other appeal is there,
Yes.
you can agitate this
No.
point.
They have got my case is that is the not 20 and 10. There is 18 and half and 11 and half. Unless
that
I
is-
can establish my right.
That is your defense in the suit for partition.
ভাই তো বলিনি, হুজুর জিজ্ঞেস করেছেন। মানে
That is your case in
In
the
the
suit for
suit,
partition.
in the suit.
Suit for partition,
In the suit for partition.
you have
they
taken
claim-
the,
You know, in suit for partition, they claim 20 decimals.
yes,
And they say that we are. the
what is
owner
your
of
case?
10.
Your
Yes.
case is,
They are the owner of 18 and half. And
So-
we are owner of 10 and
that is
11
your,
and half.
that is your case in partition suit.
Not in the.
Yes.
the case.
Yes, because
And
I beg apology, I beg
Order
apology.
is referred.
What is
I beg
Yes.
apology, my lord,
Call the
kindly
next
appreciate only one thing,
No.
my lord, kindly.
No, you don't have.
All is disturbing. What is that?
Order is reserved. Call the next one.
My lord, kindly appreciate, I beg apology, my lord, kindly appreciate.
No, no,
I beseech your lordship, kindly appreciate.
no,
I
no,
beseech
no,
your lordship.
enough. Call the list.
Both the suit was heard analogously.
You are not permitted to make your submission,
Well,
sir.
kindly excuse me to read.
Yes, call the list.
I'm sorry, I beg apology, my lord. Once again, I'm sorry, my lord, I beg apology.
This is not the way. This is not the way. Please understand, we should maintain certain thing here.
Both the suit was analogously heard and their suit has already been dismissed.
Make
and our
way,
suit was-
make way to your senior. He is waiting.
I beg to appear on behalf of the respondent.
Yes, Mr. Banerjee, what is your answer?
My lord, on the previous occasion, the question had fallen from your lordship about whether it is the reasonable requirement of Shaheen Khan which would now have to be considered. As Shaheen Khan had purchased the property during the pendency of the appeal, this question had fallen from your lordship. Now, my lord, it is
When did we meet last time?
my lord, the last occasion was possibly on 9th of August.
9th of August. Very well. This is your 135. Yes.
My lord, I was addressing your lordship.
Hmm.
On the previous occasion, Mr. Ghosh had addressed your lordship and had taken your lordship through various points of the lease deed,
Hmm.
as well as the other different parts of the record.
Hmm.
My lord, I had addressed your lordship on the previous occasion with respect to the lease deed. I had shown your lordship the relevant provision of the lease deed by which the lessee had been granted the right to collect rent, to evict, and to induct tenants in respect of the
Mhm.
property. Now, my lord, I had also shown you how rent had been paid by the present appellants before. I will take your lordship through it once again, just as a recap.
Yes, to Shakil Ahmed. Rent was
Shakil
paid
Ahmed.
to Shakil Ahmed.
Rent was paid to Shakila.
Yes.
That was there both in the written statement as well as the
Yes,
written
it is
part of the
admitted
judgment.
position.
That was the end.
Hmm.
Now, at that point of time, my lord, a question had fallen from your lordship
Hmm.
about whether it is the reasonable requirement of Shaheen Khan which would now have to be considered.
Hmm.
As Shaheen Khan had subsequently purchased the property during the pendency of the appeal. In this respect, my lord, it is my respectful submission that during the consideration of the second appeal,
Hmm.
the honorable court is confined to the correctness. I should not say is confined, my lord will.
What
kindly
about
pardon me.
section 103?
No, my lord, I'm just coming to that. My lord, I'm coming to that. Your lordship would consider before section 103, although it is well within your lordship's knowledge, I would just beg your lordship's indulgence to take your lordship through section 100.
Yes, you read it.
Section 100 is second appeal.
Hmm.
Save as otherwise expressly provided in the body of this code,
Hmm.
or by any other law for the time being in force.
Hmm.
An appeal shall lie to the High Court from every decree passed in appeal by any court subordinate to the High Court.
Hmm.
If the High Court is satisfied that the case involves a substantial question of law,
Hmm.
an appeal may lie under this section from an appellate decree passed ex parte.
Hmm.
In an appeal under this section,
Hmm.
the memorandum of appeal shall precisely state the substantial question of law involved in the appeal.
Hmm.
Where the High Court is satisfied that a substantial question of law is involved in any case, it shall formulate that question.
Hmm.
Now, pausing here for a moment, my lord, in the instant case, the order by which the instant appeal was admitted, the order of July 2019 passed by the Honorable Division Bench, my lord, the questions of law, the substantial questions of law were formulated. There were two substantial questions of law which Mr. Ghosh has addressed.
Hmm.
The appeal shall be heard on the question so formulated, and the respondent shall, at the hearing of the appeal, be allowed to argue that the case does not involve such question, provided that nothing in this subsection shall be deemed to take away or abridge the power of the court to hear, for reasons to be recorded, the appeal on any other substantial question of law not formulated by it, if it is satisfied that the case involves such question. The proviso is there. Now, your lordship will kindly turn to section 103. Power of the High Court to determine issues of fact.
Hmm.
In any second appeal,
Hmm.
the High Court may, if the evidence on the record is sufficient,
Hmm.
determine any issue necessary for the disposal of the appeal,
Hmm.
which has not been determined by the lower appellate court, or both by the court of first instance and the lower appellate court,
Hmm.
or which has been wrongly determined by such court or courts by reason of a decision on such question of law as is referred to in section 100. Now, it is my submission that the factual position can be determined by the honorable court if either of these two considerations are.
Now, what about the subsequent event?
Now, my lord, if it is a subsequent event, now, my lord, it is my respectful submission that the subsequent event, the deed of sale, that cannot be the ground to void the decree. Why I am submitting before
Void the
void the decree? Why I am submitting
yes.
before your
Hmm.
lordship? In this case, what has happened? There was a decree which was passed by the learned trial court.
Hmm.
Subsequently, that decree
on the ground of reasonable requirement.
the decree on the ground of reasonable requirement was passed by the learned trial.
Hmm.
Subsequently, that decree was upheld by the learned first appellate.
Hmm.
certain substantial questions of law were obviously identified by their lordships, the Honorable Division Bench, and the appeal was pending. During the pendency of the said appeal, a deed of sale was executed. Shaheen Khan became the owner of the property. Now, my lord, it is my submission that Shaheen Khan's right over the property or Shaheen Khan's use and enjoyment of the property will be subject to the result of these proceedings. The appeal which has been preferred by your lordship, before your lordship, will either succeed or it will fail. These are the two options, my lord, subject to correction, and lordship will excuse my impertinence if I have been impertinent. It will either succeed or it will fail. If the appeal succeeds, then Shaheen Khan's right or her use and enjoyment over the property will be subject to the Vaidyas remaining as the occupiers in respect of the suit property. Contrarily, if Shaheen Khan, if the appeal fails, if the appeal does not succeed, in that circumstance, Shaheen Khan's use and enjoyment of the property will devolve accordingly. So it is my most respectful submission, my lord, that the correctness of the decree which has been passed will have to be considered on the basis of the substantial questions of law. And naturally, if your lordship going through the record, if your lordship going over the materials on record before your lordship finds that there was any other issue as has been contemplated under section 103. That is my submission. Because if your lordship considers, if I may be permitted to place an analogy before your lordship.
Yes.
In a hypothetical situation, instead of
at the end of the day, you are an advocate. You have every liberty, which we don't have. So please continue. But you are not answering to my query. What would happen to the subsequent event?
No, I'm just coming to it. I'm just trying to place it. My lord will consider an analogy, a hypothetical situation. Instead of Shaheen Khan, suppose for a moment, for argument's sake, the property had been purchased by Shakil Ahmed.
Shakil Ahmed.
Shakil Ahmed, who was the lessee. If the lessee had purchased the property, one of the substantial questions of law which has been formulated in this case is the right of a lessee to file a suit for eviction. Now, had this been the case, if the subsequent development was to be considered by the Honorable Court, then that point would have gone. Because Shakil Ahmed, by right of ownership, now has every right under the Transfer of Property Act and under the relevant provisions of law. So that point could not have subsequently been taken. My lord, it is my submission that once a decree has already been passed and once the substantial questions of law have been formulated, then the Honorable Court, while determining the appeal, will determine the appeal under the provisions of section 100 and under the provisions of section 103. The subsequent development in this case, my lord, it is my respectful submission, as I just submitted a little while back before your lordship. The effect of the deed of sale.
If this appellant, what is the name? Shakil and Prakash Chand Vaid, suppose Prakash Chand Vaid purchase the property during pendency of second appeal.
My lord, if Prakash Chand Vaidya had purchased the property during the pendency of the second appeal, then my lord,
and there are other appellants.
No, Prakash Chand Vaidya and all the other appellants are.
No, only Prakash Chand Vaidya is purchasing.
Well, Prakash Chand Vaidya is holding the property, possibly again subject to correction, along with his family members.
Yes, but that cannot stop him acquiring the property. What would happen in that event? Instead of Shakil, property is purchased by Prakash.
Well, then again subject to correction, possibly that the rights of the other appellants in that regard.
Yes.
The rights of
Prakash may be transposed from
But
the position of appellant to respondent.
Yes, but my lord, the appeal itself would not have abated in that.
No, I am not on abatement. I am on the requirement of Shaheen.
Well,
Vis-a-vis Shahil, or what is the name? Shaheen and Shakil.
Yes, my lord. My submission is, my lord, that the
You replace Shakil
My lord.
by Prakash. Now visualize the situation.
My lord, I appreciate your lordship's point, but my lord, there again, the effect of that subsequent conveyance cannot be to void the decree.
No, decree is fine. But I am to look into the requirement. That is the only ground based on which decree was passed. Reasonable requirement.
My lord is correct. No, my lord.
It is absolutely subjective requirement.
My lord is correct. No, my lord.
So the question is whether requirement of Shakil would be the requirement of Shaheen without any evidence on record. That is question number one. You were giving an example
My lord.
that had Shakil
My lord.
been the owner of the property
Right.
instead of lessee,
My lord.
then the position would have been the same.
Right.
Now replace Shakil. Bring in his place Prakash.
Right.
What would be the position?
My lord, there again, my lord, the decree, even during the stage of second appeal, had Mr. Vaidya purchased the property.
Decree is on the ground of reasonable
Yes, your
requirement.
lordship is
Yes.
correct, but the decree, even if it is on, my lord, again, my respectful submission, that even if the decree is on the ground of reasonable requirement, the effect of a subsequent conveyance cannot be to void the decree. Now, why I am raising this point of voiding the decree, your lordship will appreciate one thing. As I said before,
Let us go further.
My lord.
How many rooms are there in this suit building?
my
Say,
lord,
let us assume 10 rooms are there.
my lord,
And the appellants are occupying 4 rooms.
my lord.
Rest 6 rooms were occupied by tenants who surrendered their possession. And you are inducting new tenants over there.
Right.
What would happen to this suit?
My lord,
Can't the court look into the subsequent event
my lord, again, there, my lord, my
to
submission,
determine your reasonable requirement
my lord, there again, my lord, again, it
in
is,
the light of section 103? Don't
Right.
confine yourself within the parameters of section 100 only.
no, my lord, I'm just coming to section. If I may again turn to section 103. The power of the High Court to determine issues of fact. In any second appeal, the High Court may,
No,
if
no,
the
it's
evidence
not
are-
there, Mr. Banerjee. It's not there. It is something happened subsequent to the passing of the decree by the first appellate court
Yes,
during pendency of the second appeal.
yes.
There was no scope for the first appellate court to consider this.
So, my lord, that is my lord, again, there again, as I said before, your lord,
Yes,
my, say, Shaheen Khan's right or enjoyment or use over the property will naturally be subject to the outcome of the appeal. Now, why I am saying so? As I said before, your lordship, suppose the appeal succeeds. If the appeal succeeds, then Shaheen Khan will have to enjoy the property or use the property with the Vaidyas remaining as occupants in respect of that property, in respect of the suit premises. If the appeal does not succeed, then she will be able to enjoy it without the Vaidyas as the occupiers of that suit premises. But my lord, it is my submission that the effect of a subsequent development cannot be to void the decree.
very well.
My lord, that is my submission on that point.
Fine.
Now, lordship, on the previous occasion, two essential points of law had been raised, or two substantial questions of law had been raised by the learned senior counsel appearing on behalf of the appellants. The first point is with regard to the splitting of the tenancy. The second point, my lord, is with regard to the right of the lessee to file the suit for eviction in this particular case. Now, if your lordship sees, with regard to the splitting up of the tenancy, my lord, on the previous occasion, your lordship had seen that there were two separate letters of atonement.
Yes.
Those were exhibited as Exhibit C. Now, my lord, the first letter was on 14th of April 2004, and the second letter was on 24th of August 2004. Now, my lord, the instructions that I have is that there were two letters of atonements because there were two distinct tenancies. Now, my lord, on the previous occasion had come across a letter which was given by the predecessor in interest
Hmm.
of the present appellants to the then owner of the premises, Sajda Khatun.
LC একটা দিন yes you can.
Yes. That was a letter dated the 8th of September 1980. Now, in that letter, my lord will remember, there was an indication of the splitting up of tenancies because there were two separate rents. Two separate rents and two separate and distinct provisions had been mentioned in the said letter. The letter dated 8th of September 1980. Now, my lord, an interesting aspect of this case is the agreement had never been exhibited, nor was any document ever exhibited to show that there had been an amalgamation of tenancies. My lord, had there been only one tenancy, had there been only one agreement in respect of the property, then, my lord, there would not be a question of demarcating that I am paying X amount of money as rent in respect of such and such portion of the property and Y amount of money in rent in respect of another portion of the property. Now, my lord will kindly once turn your lordship's attention to the judgment which was passed by the learned trial.
That page. Yes.
Now, my lord, I am reading from the paper book, internal page
Page
13.
13.
13.
Yes.
My lord, the last but one paragraph,
Yes.
it starts from as an answer to this. As an answer to this, the learned advocate for the plaintiff submits that there are two tenancies in the name of the defendants. And presently, the plaintiff has filed this case for eviction of the tenancy in relation to the suit property only. This tenancy consists of one room on the ground floor with space open to sky and privy situated on the ground floor of premises number 129 Ravindra Shah. Now, the next line, this is the trial court's observations in this regard. Now I scan the evidence in respect of the schedule of the plaintiff. The plaintiff has filed a true copy of the notice which has been marked as Exhibit 3. Exhibit 3 is the notice. In the said notice, the property as described in the plaint is depicted entirely. So, my lord, the notice, the point had been raised before the learned trial court that the notice was not given correctly. And as the notice was allegedly not given correctly, then the suit would fail on that ground. But the description of the suit property in the notice as well as in the schedule of the plaintiff, my lord, is identical. That was observed by the learned trial. Now, my lord, another aspect on this point, if your lordship turns to page 18 of the judgment. I'm with your lordship. Second paragraph. In the cross-examination of the DW1, Mr. Vedya himself had been examined as DW1, the appellant before your lordship. He has admitted that the prior landlord was Sajda Khatun and admitted that the signature of the defendants in the AD card. He also admits that the extent of tenancy described in the notice to be correct after going through the notice. So there was an admission on his part. There was no further clarification. There was no further re-examination of that witness on this point. On this ground, my lord, the submission that the notice did not extend to the entire tenancy and that it was not served does not find any justification. Now, that's the first point. Now, my lord, no agreement had ever been exhibited. The defendants in the suit, who were the appellants before your lordship, had exhibited a number of properties, had exhibited a number of documents. No agreement was ever exhibited in order to support their contention that they were the tenants, or there was only one agreement in respect of the entire property.
Hmm.
No such document, my lord, was ever executed. Now, lordship will find one interesting aspect of this case.
Hmm.
2 letters of atonement were given.
Hmm.
There was never any reply from their side. There was never any reply saying that you are not the tenant, so there is no question of paying rent to you. Nor was there ever any reply from their side saying that, or to the effect that, there is no splitting up of tenancy. You have not described the tenancy correctly. There is only one tenancy in respect of the entire property. So the fact of 2 letters of atonement is bad in law, or is not tenable. There was no reply to that. Instead, my lord, what did they do? They started paying rent. Those rent receipts, they were initially attempting to pay rent directly to the lessee, Shakil Ahmed. Shakil Ahmed refused to accept it. They started paying before the rent control. Those rent receipts, those challans were exhibited. And then subsequently, after the initiation of the proceedings, what they did was they filed the application under 7.1 and 7.2 of the West Bengal Premises Tenancy Act. And after the order of the learned trial court, they started depositing the rent over there.
Hmm.
I'm just asking myself, your lordship, had this been their contention, there would have been some document to that effect. It would not have been the contention of the appellant before your lordship during his cross-examination before the learned trial court that the description of the suit property in the notice was correct. The extent of tenancy described was correct. It would not have been that contention.
Now, Ms. Banerjee,
My
please revisit
lord, here
exhibit A.
my lord, I must have make one candid submission.
Yes.
I do not have a copy of the exhibits. If your lordship
You
could-
take the document.
আমার কাছে আছে। আমার mark করা Thank you. Exhibit A, this, my lord, the list date.
Exhibit A is a copy of the letter dated 8th of September 1980, given by Govindlal Vijayalal to Ms. Sajda Khatun.
My lord will just
That is my predecessor.
Yes,
89.
the original tenant.
My lord.
And then come to exhibit C.
Yes. That's
Hmm,
Lordship, two things.
yes,
If your Lordship comes to page 89, that was the letter of 1980.
89 of paper book.
My lord, that is exhibit A. Oh,
Yes.
sorry, 89. I beg your Lordship's pardon. I'm seeing from the compilation, it was
Mhm.
generously provided
No.
by the learned counsel appearing on behalf of
Yes,
the
please.
My lord will see.
You have handed out one
Yes, yes.
compilation. Yes, it's there. এটা দিয়ে দিন আমি আমার এটা বার করে দিচ্ছি। আছে আমাদেরকে দিয়েছি হ্যাঁ এটাই দিয়েছে
If I may just make one aside, my lord.
Yes.
Even I am also reading from the same compilation which was so generously
Yes.
provided by the learned
Okay.
counsel appearing on behalf of the
Yes.
My lord will see page 89.
Hmm.
Two tenancies have been referred to.
Hmm.
Two tenancies have been referred to. Two tenancies have been referred to in this letter. No document of amalgamation.
Hmm.
There is no document of amalgamation, and lordship, even in the evidence, as I said before, it was the extent of the suit property as described in the notice and in the schedule of the plaintiff's client. That was not a contention which came on behalf of the plaintiff during his evidence. That came on behalf of the appellant. That is the first. Secondly, my lord will again.
Hmm.
Again, if your lordship once again comes to page 14 of the judgment of the trial.
Just hold on. Just for a minute.
One check.
Yes. Page 14.
Yes. This point was again raised
Hmm.
before the learned trial.
Hmm.
That in the letter of atonement,
Hmm.
the entire property was referred to.
Hmm.
The first floor, the second floor. Now here, the last line of the paragraph, the entire point was dealt with by the learned trial court. The challenge to the suit property schedule was not well grounded. So that point was considered by the learned trial court and rejects. That's the second point.
Hmm.
Now, my lord, another point which was raised by the learned counsel appearing on behalf of the appellants
Hmm.
was with regard to the right of the lessee to file a suit for eviction. Once again, I will turn your lordship's attention to the lease deed for one.
Exhibit 1.
Exhibit.
Yes.
The previous occasion, the learned senior counsel, during the course of his arguments,
Hmm.
had raised various points and had
Hmm.
placed various provisions of the lease deed.
Hmm.
I do not wish to repeat. Just one point. Internal page 9.
Hmm. Just give me a minute.
Yes,
Internal page 9.
internal page.
Hmm.
Point number 5.
Hmm.
That the said lessee shall be entitled to realize the rents and profits from the tenants of the said premises. And the said lessee shall be entitled to evict and or to induct any tenant during the period of this lease. So the right to induct and or evict the tenant had been given in the lease deed itself. Now, my lord, it's my most respectful submission that Shakil Ahmed, whatever right he had in respect of the property, was governed and bound by the lease. Naturally, a right which was not given specifically by the lease deed could not be claimed. But such right over here was specifically mentioned. Now, I will come to the judgments also which were cited by Mr. Ghosh on the previous occasion. Just before that, my lord will appreciate one thing. Whether a lessee has a right to file a suit for eviction or not. On that occasion, on the previous occasion, again, I had taken your lordship through the various provisions of the West Bengal Premises Tenancy Act. Just to refresh,
আদিত্য আমাকে একটু 97 একটা দিন premises tenancy act. Yes, actually, we will find it out. Yes,
yes. My lord will kindly come to section 2,
section 2.
subsection C.
Hmm. Yes,
My lord will see. Yes. My lord will kindly come to section 2, subsection C,
yes.
the definition of landlord.
Hmm.
Landlord includes any person who for the time being is receiving or is entitled to receive the rent for any premises, whether on his own account or on account of or on behalf of or for the benefit of any other person, or as a trustee, guardian or receiver for any other person, or who would so receive the rent or be entitled to receive
Which
the
is-
rent if the premises were lent to
Which is why I asked you the other day, did you receive rent from them? Did they acknowledge you as your
Yes.
landlord? You said yes. So
Yes, sir.
this point is okay.
Yes, sir. So no, the point that I was saying, my lord, again, your lordship knows this far better than I. That the prerequisite of ownership
Hmm.
in order to act as a landlord, in
No,
order
no,
to,
in this new act, it has been
it has
given a
been
go
given
back.
a go.
Yes.
The lessee has that right. My lord. That
Yes.
is my submission. Now, my lord, two judgments
Hmm.
on the previous occasion had been cited by Mr. Ghosh.
Hmm.
One was the judgment which was reported in 2005, volume 2, Calcutta High Court Notes, 509. Now, my lord, this judgment,
Just hold on, let me find it out. আদিত্য citations গুলো কোথায়? Yes, yes,
this was the judgment,
Hmm.
2005, volume 2, CHN 519.
yes.
The judgment of Shambhunath Mitra and others versus Khaitan Consultant and
Hmm.
others. This was a judgment passed by the division bench of this honorable court by their lordships, the Honorable Mr. Justice Bhaskar Bhattacharya and Rajendranath Sinha as their lordships. My lord, this judgment subsequently went on appeal before the Honorable Apex Court.
Hmm.
On a technical point, my lord, this judgment was set aside. This is the judgment. It is reported in 2015, volume 15, SCC 567. Copy, my lord. On a technical. My lord will see. This is the judgment passed by Justice Dave and Justice Goel. Shambhunath Mitra versus Khaitan Consultant, reversed on a technical point. No comment was made by the Honorable Apex Court on the ratio which was laid down in this judgment. That is a point. But my lord, it was reversed on the technical point, and it was subsequently reverted back to this honorable. If your lordship turns to paragraph 5 of this judgment, 2015, volume 15, SCC 567. The appeal shall be notified for hearing by the High Court on 2nd of November 2015. And it would be open to the parties to raise all contentions permissible in law before the High Court. And the order of status quo prevailing as on today shall continue till such and such. The said order may be modified by the High Court after hearing the parties concerned if thought necessary.
Maybe, perhaps this is the appeal pending. Actually, I had the opportunity to.
Yes, Lordship, when I discovered this yesterday, I was attempting to search for what had happened to these appeals, because if your
It was
lordship
pending before
or
Honorable Justice
division bench
Yes.
comprising of your lordship and Honorable Mr. Justice Shane,
Shane, yes.
there are a number of appeals between these parties. It appears to be a very hotly contested litigation. But my lord, this judgment which was laid down, it was reversed on a technical. It is my contention. That's the first. Second thing, my lord, is this. The concept which has been dealt with in this particular judgment, my lord, or the concept which was attempted to be raised by, I will take your lordship to the various points of that judgment. No doubt. It is dealing with the principle of concurrent lease. That is a concept which is there in English law. Now, my lord, I was unable to take a printout of this. If your lordship may permit me to consult my phone to see.
Yes, yes, do it.
My
In this era of technology, how can I stop you?
lord, I am grateful. This is the Oxford reference, the concept of concurrent lease. A lease granted by a landlord.
But you need to take out.
I will take out the printout and I will place it before
Yes.
your lordship. One indulgence I will just seek from your lordship right now. I will complete my One indulgence I would seek from your lordship right now. I will complete my submissions today. Your lordship will just permit me to file a written. I will produce a copy. I will certainly share a copy with Mr. Ghosh if that helps.
But by tomorrow.
It will give me till Monday.
Burn your midnight oil, you are a young man.
Kindly grant me till Monday. That is the only. Second indulgence. I
Okay.
should not say only.
If he gives me by tomorrow, my lord, then I can, next week, I can do. On
I
Monday,
will do so. I will do so.
because I have to go through it. And
I'm very grateful. Because I will need the hard copies of this also.
Yes, just annex it to your.
Yes, of course. A lease granted by a landlord to run at the same time as another lease of the same premises. The effect is that the lessee of the concurrent lease acquires the rights and duties of the landlord in relation to the other lease. So this is the concept of concurrent lease. The prerequisite of this is there has to be two leases. Here there are no leases. It's not a case of two leases. There is a tenancy. There is a tenancy. It is nobody's case that the appellants were the lessees in respect of that property. They were the tenants in respect. And my lord, had this been the case, had it been the position of law that the lessee had no right in respect of the tenants, then my lord, it is my respectful submission that the amendments to the Act of 1997, my lord, would not have. That is my submission, as far as my understanding is. Now, one interesting point in respect of this judgment, Shambhunath Mitra and others versus Khaitan Consultant Limited and others, the eviction suit which took place was dealing with the Act of 1955. Because if your lordship sees
Yes,
title suit number 3099 of
999.
1996, say Act of 1955. At that time, my lord, this amendment had not taken place. Now, my lord, will find certain paragraphs of this. If your lordship straight away turns paragraph 27.
27 of the judgment.
Yes, paragraph 27 of this judgment. As pointed out earlier, and I'm reading. As pointed out earlier, the title suit number such and such was filed by Khaitan Consultant Limited, claiming eviction of and mean profits from the appellants by treating them as rank trespassers. It was the contention in that case, my lord, that the Shambhunath Mitra and their family members had no right at all in respect of the property. They were trespassers. They did not have the authority or the permission to occupy that property. But it is not the case over here. It is not the case of the plaintiff before the learned trial court that the Vaidyas were trespassers in that. They were the tenants in respect of the property. The suit was filed on ground of default, which was decided against them, and on the ground of reasonable default. But nowhere was this question of illegal occupation or trespassing. That was not raised. That is not the case over here. That is the first point. Now, subsequently, my lord, my lord will kindly allow me one moment. Paragraph 28 once again has dealt with the concept of concurrent lease over here. That's the next paragraph. That has been dealt with the concept of concurrent lease over here. Well, again, I raise my submission that that will not be applicable in this case because it is a tenancy, not a lease. Now, this particular judgment, my lord, paragraph 31. This particular judgment of Shambhunath Mitra versus Khaitan Consultant, it was passed on the ground that the other judgments which had been cited on behalf of Khaitan Consultant did not consider the judgment of the Privy Council in the case of M.E. Mullah and Sons Limited. Now, my lord, in order to arrive at that, before we come to paragraph 31, I would just like to invite your lordship's attention to paragraph 29, paragraph 30. Paragraph 29. Mr. Mitra of the Learned Counsel, appearing on behalf of the plaintiff's respondents, has strongly relied upon the aforesaid two decisions in the cases of Jawaharlal Putra and Sri Narayan Mansinka, and has contended that by virtue of the said concurrent lease, his client is entitled to maintain the suit for eviction. Paragraph 30, in our decision, the decision of the division bench in the case of Jawaharlal Putra is no longer good law in view of subsequent decision of the Privy Council in the case of M.E. Mullah and Sons Limited versus official assignee of the High Court of Judicature at Rangoon and others, reported in 65 CLJ 275 within brackets PC. Similarly, the subsequent decision of the division bench in the case of Narayan Mansinka Supra cannot be treated as a valid binding precedent as the said division bench failed to take note of the earlier existing Privy Council decision. On that ground, my lord, because the judgment of M.E. Mullah and Sons Limited was not considered, the contention of concurrent lease or the contention was not accepted. My lord, here the question in Emi Mulla has also been described in section 30, in paragraph 30. In the case of Emi Mulla and Sons Limited Supra, the question was whether a deed authorizing somebody to realize future rent and profit was compulsorily required to be registered under the provision of section 17 of the Registration Act. That was the question which was concerned by the which was considered by the Privy Council in that case. In the context of such a case, the Privy Council, through Sir George Rankin, held that right to future rent is a right in immovable property, and if such right is transferred in favor of third person, such transfer must be effected in accordance with the provisions of sale contained in section 54 of the Transfer of Property Act. That was held in that context. Whether the right needs to be a registered instrument. In other words, their lordships were of the opinion that a right to realize future rent and profits from immovable property can be created only in accordance with the provisions contained in section 54 of the TP Act, meaning by sale. Therefore, it is the effect of a concurrent lease is to authorize second lease. Their lordships have read this to mean that this concept is not there. But the judgment which was passed by the Privy Council
Mr.
was
Banerjee, I will request you to read the entire paragraph.
According to section, if we accept the contention of Mr. Mitro, that such right can be transferred also by creating a concurrent tenancy, we shall be acting contrary to the decision of the Privy Council in the case of Emi Mulla and Sons Limited Supra. According to section 107 of the Transfer of Property Act, for the purpose of creation of a lease of an immovable property, other than according to section 107 of the Transfer of Property Act, for the purpose of creation of a lease of an immovable property other than from year to year, or for any term exceeding 1 year, or reserving a yearly rent, for the exceeding 1 year or reserving a yearly rent, oral agreement accompanied by delivery of possession is sufficient. Therefore, if a property is already the subject matter of a tenancy during continuance of such tenancy, the landlord cannot create another monthly tenancy over the self-same property by taking advantage of the doctrine of concurrent lease in violation of the provisions contained in section 54 of the Transfer of Property.
This is the point.
This was
Mr.
the point
Ghosh.
which was raised by Mr.
Yes.
Now, my lord, my submission in this regard is, as I said previously, this judgment was already set aside on a technical ground and reverted back for further consideration.
This judgment, but judgment of Emi Mulla and Sons.
My lord, in
is
respect
holding
of
the
Emi Mulla and Sons, my lord, in this regard, the question which was there was whether the deed authorizing somebody to realize future rent and profit was compulsorily required to be registered under the provisions of section 17 of the Registration Act. So the question, my lord, respectfully over there is whether the document or the deed by which the person is being authorized to realize future rents or profits is required to be registered on. In this respect, lordship can see from the lease deed of 8th April 2004, this is a registered document. The lease deed by which Shakil Ahmed became the lessee in respect of the property, my lord, is a registered document, and it is a lease deed for a period of 50 years.
But will the lease deed do? There is a reference to section 54 of
My
the
lord, I
TPA.
can
Yes.
satisfy your lordship. Now, my lord, in the next paragraph, their lordships also dealt with section 109. We are therefore of the view that a third party can get the right to realize rent from existing tenant or to sue the existing tenant for eviction only by transfer of such right in accordance with the Transfer of Property Act. We are quite alive to the provisions of section 109 of the Transfer of Property Act, according to which where a lessee transfers not the property leased or part thereof, but any of his interests therein, any third party acquiring such interest therein can become landlord of the property. In our view, the phrase any of his interests therein appearing in section 109 of the Transfer of Property Act means those interests which the lessor was capable of transferring after execution of the first lease. Once a lease has been executed and the lessee has been given right to enjoy the property, the landlord cannot have such right anymore. The only right that he is capable of transferring at that point of time is the lessor's right. Now, my lord, when this question, pausing here for a moment, when this question of first lease comes, as has been mentioned in the judgment, my lord, we are presupposing a situation where there are two leases. But here, this is not a case respectfully of first lease and second lease. Here, what had happened, my lord, there was only one lease. The lease by which Sajda Khatun gave the lease rights to Shaheen Khan,
How would you
to
like
Shakil Ahmed.
how would you like to respond to this observation?
My lord.
Therefore, if the effect of a concurrent lease, let us forget that. Therefore, if a property is already the subject matter of a tenancy, during continuance of such tenancy, landlord cannot create another monthly tenancy over the self-same property by taking advantage of doctrine of concurrent lease, in violation of the provisions contained in section 54 of the transfer of property.
In that regard,
So,
my lord,
Emi Mullah, perhaps underscoring the requirement of transfer under section 54, not by way of lease.
my lord,
Of course, subject to correction.
no, my lord, Emi Mullah, again, subject to correction, what could be gathered from this? Emi Mullah dealt with the point of the right to realizing future rents and profits. According to the judgment laid down by the Privy Council over there, that had to be governed by the provisions of section 54 of the Transfer of Property Act. And my lord, in this respect, 2 points. Lordship, as I said once again, this instant case, my lord, will not be covered under the doctrine of concurrency. That is my submission. It will not be covered by the doctrine of concurrency, number one. The second issue is, your lordship will appreciate, I once again refer to the premises tenancy. Because had this been the situation, Emi Mullah, your lordship will again appreciate, was passed before the Privy Council long before the coming into existence of this act. The virus of this act has not been challenged. The virus of this act stays. But had that been the situation, had that been the position, it could not have been the legislature, or it could not have been the position of the legislature, that the prerequisite of ownership in order to act as the landlord, or the prerequisite of ownership, lordship will once again consider section 6, the prerequisite of ownership to file a suit for eviction on the grounds of reasonable requirement, well, that could not have been given a go by. And my lord, again, respectfully to the judgment and respectful to the learned senior counsels who had appeared on that judgment, perhaps this point also, that this is not a case of concurrent lease, was not argued before their lordships on this occasion. And once again, my lord, as I said before, this judgment on a technical point was reversed. Now, my lord, although their lordships in the judgment of 2015 SCC did not make any comment in regard to the ratio, their lordships reverted back the matter to the Honorable High Court for further consideration of the appeals. And the liberty was given to raise all contentions available in law. That is the point. And as lordship knows better than me, my lord, perhaps.
No.
And as lordship knows better than me, my lord, perhaps the appeals are still pending on further consideration. The second judgment, which was raised by Mr. Ghosh, 2006, Volume 1, CHN 12. 2006, Volume 1, CHN 12. Once again, this is a judgment passed by the same Honorable Division Bench. This is a judgment of Shukumar Shaha versus Shamal Kumar Shaha and others. My lord, here, my lord, here the point was with regard to a trespasser. It was with regard to a trespass.
Hmm.
It is not anybody's case that the Vaidyas were the trespassers. They were the tenants. Subsequently, a proceeding was instituted. They were not the trespassers.
Hmm.
The Lordship will come. Para 2. This is the head note held. Roman 2. We are of the view that a lawful tenancy can be created in favor of a person by a lessor only if the lessor is capable of giving khas possession of the tenanted portion in favor of the lessee. If a particular property is in occupation of a trespasser, without evicting such trespasser, the lessor cannot create a lease over the portion so occupied. The operative portion here is trespasser, someone who is occupying without any permission. That is my submission. Now, your Lordship will also
come to triple I.
lease is a doctrine of separation of title and possession.
Hmm.
A lessor before grant of lease enjoys the title over the property as well as the right to immediate possession thereof. The moment such a lessor creates a lease, the title remains with him, but the right to enjoy the property is transferred to the lessee, and he is not entitled to enjoy possession thereof by himself so long the lease continues. Therefore, no tenancy can be lawfully created by a lessor unless he is in a position to deliver actual physical possession of the property in favor of the tenant. Well, that is why, again, subject to correction, why that provision was there, the right to induct or evict tenants. That is my point. Your Lordship, in the previous judgment, my Lord, section 109 of the Transfer of Property Act was also referred to. Your Lordship will permit me once. The rights of lessors transferring. If the lessor transfers the property leased or any part thereof or any part of his interest therein, the transferee in the absence of a contract to the contrary shall possess all the rights, and if the lessee so elects, be subject to all the liabilities to the lessor as to the property or part transferred, so long as he is the owner of it. But the lessor shall not, by reason only of such transfer, cease to be subject to any of the liabilities imposed upon him by the lease, unless the lessee elects to treat the transferee as the person liable. Provided that the transferee is not entitled to arrears of rent due before the transfer, and that if the lessee, not having reason to believe that such transfer has been made, pays rent to the lessor, the lessee shall not be liable to pay such rent over again to the transferee. The lessor, the transferee, and the lessee may determine what proportion of the premium or rent reserved by the lease is payable in respect of the part so transferred. And in case they disagree, such determination may be made by any court having jurisdiction to entertain a suit for possession of the property lease. Now, my Lord, the two provisos, my Lord, are not applicable in this case. But, my Lord, the point that I was trying to show before your Lordship, if the lessor transfers the property leased or any part thereof, or any part of his interest therein, the transferee in the absence of a contract to the contrary shall possess all the rights, and if the lessee so elects, be subject to all the liabilities. So, my Lord, all the rights may be transferred by the lessor. That is apparent from the section itself. Now, this point was considered by the Honorable Division Bench. I read out that portion to your Lordship. In 2005, Shambhunath Mitra, and my Lord, over there, the Honorable Division Bench had read this or had interpreted this provision to mean all the rights that the lessor was capable of giving. Now, my lord, in this particular case, if your lordship looks at the lease deed, no right which it was not in the capacity of the lessor to give has been transferred. No right which it was not in the capacity of the lessor to give has been transferred.
Lessor was not in a position to deliver physical possession of the property. That is admitted possession. The entire property
They were
was
the
occupied.
tenants. They were the tenants in respect of that property. They were not the illegal occupiers or the trespassers.
Yes.
This judgment,
So he was not capable of transferring the possession in favor of the lessee.
but he was subject to correction again. The question of
Hmm.
Transferring the rights,
Hmm.
the right to induct and the right to evict tenants.
Hmm.
Well, that was transferred. This lease deed, lordship was never challenged. This lease deed, my lord, had never been challenged by any person.
Lease deed between Shadida and
Sajda
Shakil.
Khatun and Shakila. The lease deed on the basis of which he subsequently entered into the premises, that was never challenged.
Hmm.
My lord will permit me until Monday to file the written. I will hand over a copy to Mr. Bursil's.
Very well. You come back on Monday.
Monday I will hand over the copy. Monday I will.
My lord, this will
He will respond in writing only. He will be submitting. Are you going to address the court on the point of law?
my lord, the,
No, in that event, it's okay.
since he is filing a written argument.
So you want to
kindly give
return?
me permission to
Yes, yes.
hand over. Somebody.
When may I expect?
My lord, I can hand over a copy on Monday. Monday.
But my London is very fond of choosing dates, my lord, which is not favorable to Saturday, Tuesday, my lord, I don't like.
Oh, sit down. I'm Monday.
তুমি হ্যান্ড ওভার করে দিতে পারো
হ্যাঁ সেটাই বলছি। আমি সোমবার থেকে
শনিবার দিন দিয়ে দিতে পারো দিয়ে দিও আমিও তোমার মেল আইডি দিয়ে দেবে
আইডি দিয়ে দিতে তো আমি তোমাকে সোমবার দিন হার্ড কপি দিয়ে দেবো।
আমি লিখব আমি তো ডিসকাশন
And Mr. Ghosh,
yes
Mr. Banerjee, have you finished?
Yes, ma'am.
What is your take on section 103 in this particular case? Subsequent event that has taken place during pendency of the second appeal. Whether court can look into that issue or not.
my lord according to me my lord that question will come in later if he can wriggle out of the position of my initial argument
No, the-
otherwise not
And the thing is, your this Shambhunath Day, it doesn't hold the field anymore.
no
Yes, it has been set aside by the apex court.
not on legal grounds
No, in its entirety, it has been
not on legal points
it has been sent back on remand. Actually, no point was discussed or accepted by Honorable Apex Court. In its entirety, it goes then how you can press it into service now.
well, that I shall
That is one important aspect you need to assess the court. With this 2015 5 SCC 567,
I've handed over a copy.
this judgment goes.
that is that judgment by which
Yes, concurrent lease, etc., whatever is there. Negating the right of the third party. And second thing, if we consider the issue involved in 2006 one CHN 12 in distinction with the definition of as given in 2C, what would be the fate of this decision?
My lord, I shall deal with.
These are the points. 2C is clear enough, conferring right upon Shakil to act as landlord. You have acknowledged his status as landlord. Having accepted that, can you now take a U-turn?
That is on the basis of the letter of account.
Yes.
Not that, my lord, I have out of my own accepted.
No, fine.
On
But
the basis of the letter of account.
but landlord as defined under section 2C, it includes any person who for the time being is receiving rent. Your client has acknowledged Shakil as their landlord by tendering rent to him. Having acknowledged his status as landlord.
That has also been dealt with, my lord, in the two judgments, my lord, I have cited. As far as I remember.
So please remember to highlight this
Yes.
point in your written notes.
Just one thing, my lord, I omitted, it was my mistake. 2006, volume 1 CHN.
Mm.
That judgment was also dealing with a case which was under the Act of 55.
56, yes.
55 or 56. Because the title suit was of
88.
1982.
Yes, that I have seen. How landlord? Do you have the copy of old act
I don't
with
know,
you?
with
No.
me right now.
That's it.
Mr. Banerjee,
No.
56 act? No.
Right now, I
Anyway, I need to go through the definition of landlord there. Thank you. So hearing is concluded. I am reserving for judgment and expecting your response by.
it depends upon my learned friend.
I will hand over
When-
a copy. I will hand over a soft copy by Saturday, a hard copy if it's required by Monday.
Unless I get it by Saturday, my lord, I shall give dictation to my learned junior, my lord, on Sunday. In the weekdays, my lord, during the weekdays, my lord, it will be impossible for me, my lord, to.
No, the difficulty is then I will not be here from say 25th will be the last working day.
25th,
25th of August. Thereafter, I have to move to Jalpaiguri to attend the circuit bench. Then,
and then your lordship also, as Mr. Milan Mukherjee, my lord, was mentioning one.
no, one
Your
matter
lordship
that
is
is
sitting-
tomorrow. Yes, that is tomorrow. Tomorrow we have another matter, very embarrassing criminal matter, which is why Mr. Mukherjee came to take the assurance whether that matter shall be taken up tomorrow or not. I don't want to discuss that issue, but it's not a very happy situation.
My lord, your lordship is going to Jalpaiguri on.
On 25th evening or on 26th, since circuit will be there on and from 28th, and it will continue. So not before 11th of September in any case.
Well, let it be tentatively fixed on 23rd.
Very good. I am not indicating any date. Try to submit by
I will hand over the
23rd.
soft copy by Saturday.
Heard Mr. Banerjee, learned counsel for the respondent, and Mr. Bhaskar Ghosh, learned senior counsel, representing the appellant,
Then
ably assisted by Jitendra Banerjee, by R. Banerjee. Hearing is concluded, judgment is reserved. but you must keep it up.
I'm very grateful
He's
to your
doing
lordship.
very well, my lord. I am
Yes.
very happy to see him.
It's
arguing
it's
such-
really a
such
pleasure.
And also, my lord, I shall thank him for another purpose. That is taking of time, my lord, serves an other purpose also.
I cannot comment.
No comment.
I'm very grateful to your lordship for giving me the
Thank
opportunity
you,
in such
but
a patient
please
way.
keep it up.
I'm okay.
Yeah, mobile.
গুলো রাখুন তো এটা কতকে পড়বে জানি।
Son, one thing. Am I not disturbing you?
No, no.
My lord, sometime back, my lord, I mentioned before your lordship, also at the instance of my junior friends, that to keep one day for appeal connected.
Yes, yes,
application.
I have instructed my officers. We are working on it. Hopefully from September it will be done.
That is one thing. And other thing is,
I
my lord,
intend to keep 2 days for civil revision and applications. Otherwise, it is really very difficult for me to find out time to prepare judgment of second appeals. That we are working on it and hopefully,
and my lord, another thing is item 122,
hmm,
which was called, my lord, yesterday
yes,
under
What?
the heading second appeal,
in today's list, it is item
122.
122.
Some Satra, Hajra, Santanu Hajra, Santana Hajra.
Let us see. Yes,
That is, my lord, really an application we have filed. The can is not mentioned there. This is not
can
for
three
the,
of, can,
this is not for the appeal hearing, but the application.
can three,
Can number, my lord, I. couldn't-
can 3 of 2023, that is it.
Yes, and one can is there,
Yes,
which we have filed.
so it should come under the heading application. আরে তো দেখুন এটা গোলমাল হচ্ছে।
Grateful.
Thank you. Yes. Doctor. Right? Yes,
On the matter, my lord asked me to decide whether it was properly stamped.
no. I told you it's your choice to
Yes, ma'am.
elect. What do you want? If you wish, I will reverse the order and ensure that your suit fails before the learned trial court. Else, you go and pay the stamp duty.
I will ready to pay the stamp duty, my lord. But the portion of the penalty that should be considered.
No, that is the statutory provision. It is always 10 times. It is the fiscal policy. I cannot comment on that.
Then, my lord,
But
on the
what is the consideration amount?
consideration, my amount is 0.
0.
That is
0 multiplied by 10 would amount to 0. Fine, then I will decide it in my own way. Leave it.
And will kindly expedite the title should.
Don't seek adjournment before the trial court.
Great.
Ask your friend over there not to seek adjournment. You are creating impediments and seeking expeditious trial. No such direction will be given. Follow the procedure. Don't seek adjournment more than 3. Yes, call the Lucy. No. এটা সব অ্যাপিল সেকেন্ড অ্যাপিল হিয়ারিং হচ্ছে নাকি অ্যাপ্লিকেশন অ্যাকচুয়ালি না 7th অ্যাপ্লিকেশন কিছু নেই ইয়েস assigned. তার মধ্যে এইটা দিন দিন তো অরুণ সাহা নাকি এসেছিল লয়ার অ্যাপিয়ার করেছিলেন আসুন এখন none is appearing on behalf of the appellant. আদিত্য আপনি ভদ্রলোককে চেনেন অরুণ কুমার শাহ 2 তারিখে অ্যাপিয়ার করেছিল let the matter be listed আজকে এটা করবো না let the matter be listed on 24th of August under the heading for orders এটা দেখি ভদ্রলোক বলেছিলেন মিস করেছে একটা কোনো করা হচ্ছে দেখি আর একটা আছে কোনটা 3টে আছে না same order পরেরটা দেখুন এই 3টে ম্যাটারেই দেখুন অ্যাপিয়ার করেছে এটা অরুণ কুমার শাহ এটা কি আলাদা এটা ওটা নয় এই করে দিন 3টে সেম অর্ডার করে what is your method
My lord, in this matter, you will also may remember that on 7th of August, this matter was taken up for hearing. And you also was granted leave to file supplementary affidavit, and we have been granted leave to affidavit in opposition. But they have not served copy any supplementary.
দেখি ফাইলটা
I am appearing behalf of the petitioner an opposite party. And
Petitioner and opposite party,
No,
this is second appeal perhaps.
They are the respondent applicant, and
Yes.
we are the applicant opposite party. Last order, you also find 7th of August.
Yes.
I mean,
Where is that affidavit? You were directed to indicate the portion
yes, my lord.
you intend to repair. Where is that affidavit?
We contact our client. We need some time.
This is not the way. Then you are not in need of repairing the suit premises. Anyway, let's dispose of the appeal.
My lord, I'm paying for short passover.
For what?
You also
Senior counsel.
granted some time to that so that you might file that.
Short
He is a
passover.
junior friend.
No, that's fine, but who is leading you? Mr. Bag. The other day, he was told to file supplementary
Yes, ma'am.
affidavit indicating the portion you intend to undertake work of repair.
This is tile set structure.
Yes, then
My lord, give me some time.
this is suit for eviction of
No,
license,
this is a
partition.
They are claiming partition. We are the absolute owner of the property. We have possessed every documents. And court considered that my mother was a chicken tenant, that's why the property inherited. Only one evidence came from the Chica controller, and there is no document. There is every papers and documents title deed with us. Those have been exhibited.
Appeal is otherwise ready.
We have 5 paper. Record is there is direction. to
LCR,
fill the LCR.
My lord, I'm
We
paying
have
for
5
short
paper.
passover. Short passover. my lord.
Well, they are 2 PM now. They have not filed application today.
I am adjourning the matter, fixing it. Say today is 17th, 21st.
21st.
You file your affidavit. On
And my lord,
21st.
there is the direction, 1 week time also may be given to file our opposition. You are also already given.
Yes, in. Heard Mr. R.N. Dotto, learned advocate for the appellant, and Mr.
Showman Pradhan.
Showman Pradhan, learned counsel, learned advocate representing the respondent. So pursuant to the order dated 7th of August 2023, the respondent is supposed to file supplementary affidavit indicating the specific portion of property. File supplementary affidavit indicating the portion of the property he is occupying, which requires the repair work. No such supplementary affidavit has been filed. Mr. Pradhan is seeking time. Let the matter be listed on 22nd. Are you okay with 22nd? 22nd?
Now, if they serve the copy,
Then I will fix it. 7 days time, then it will be, then it will
well,
be.
they will serve the copy on 22nd or 21st, and after that, we will file opposition on it. This is your direction lawsuits.
Yes. কি বললাম ওটা? না, শেষের দিকটা।
They filed application 2021. Then filed application in 2023.
হ্যাঁ। No. Fine. Be listed on the 21st of August. By which you are to submit supplementary affidavit by 21st. Stop. The appellant is to file affidavit in opposition to such supplementary affidavit within 7 days hence. The matter be listed on 12th of September.
Deep down.
In the meantime, I will not be there. Don't miss the schedule. The appeal is otherwise ready.
We have 5 paperwork, there is a direction I find from the record also, that LCR. LCR.
আসেনি
Yes.
দেখি ওই একটা লাইন দিয়ে দিন তো ডিপার্টমেন্ট ইজ ডাইরেক্টেড টু ensure arrival of
LCR.
lower court record in the meantime.
Otherwise, appeal is ready.
Yes.
With your lordship, I know.
Hmm.
My lord, we are item number 70. We are prettiness, and we have no contact with our clients.
Item number 17,
17, 18, same suit.
17, 18. Then it will be disposed of. Then আসুন ম্যাডাম মেয়েটি কোথায় গেল বাচ্চা মেয়েটি কোথায় গেল বেরিয়ে গেছে no she is there come here you move the matter what is your good name
Rutika Verma.
take the microphone
Rutika Verma.
Ju-
Rutika
Juthika
Verma.
Verma learned advocate on behalf of the petitioner submits that there is no instruction from the petitioner. Stop. From the order sheet dated 14th of July, from the order dated 14th of July 2023, it appears that stage Mr. Mahato informed the court about the death of opposite party number 1. But no step was taken to bring on record the legal heirs of the deceased opposite party number 1. Therefore, this revisional application abates as against OP number 1. Briefly stated, the petitioner filed the suit claiming title by way of adverse possession. Adverse possession against opposite party number 1 and 2. An application under Order 6, Rule 17 of the Code of Civil Procedure was taken out by the petitioner in the suit. Which learned trial court refused to allow, considering lack of due diligence on the part of the plaintiff petitioner. The order impugned does not manifest any jurisdictional error or perversity. The revisional application does not merit any consideration and is dismissed. Order of stay, if any, stands vacated. Application, if any, stands disposed of. এটা কি analogous ছিল সেম অর্ডার হচ্ছে এখানে আর বি এই একই সাথে না কারণ এটা analogous ছিল না দুই 1171 পরেরটা করুন মিস ওর নাম কি বললো জ্যোতিকা বর্মা learned advocate submits that there is no instruction. Stop. The order impugned. It is the order impugned. Briefly stated, a suit was filed against the petitioner by the opposite parties number 3 to 12, being title suit number 7 of 1993 for recovery of possession by evicting the petitioner. The petitioner took out an application under section 10 of the Code of Civil Procedure seeking stay of all further proceeding of title suit number 7 of 1993 till the disposal of title suit number 108 of title suit number 218 of 1991. Stop. By the order impugned, learned trial court was pleased to reject the said application. Stop. The order impugned does not manifest any jurisdictional error or perversity on the part of the learned trial court. Stop. The revisional application merits no consideration and is dismissed. Order of interim stay, if any, stands vacated. এই দুটোই কপি যাবে ট্রায়াল কোর্ট। Copy of the order sent down to learned trial court. Yes, call the list.
Item number 14, my lord, your lordship.
Wait. Let the matter be called on. দেখি What is your-
application arising out of a suit for preemption matter. Preemptee is the petitioner before your lordship, my lord. The suit was filed on the ground of co-sharership and inter-share, my lord. I lost, my lord. Appeal was preferred. Appeal court was affirmed the court of the planet trial court. The during against that order, appellate order, I filed this instant revisional application, my lord. During pendency of this revisional application, my lord, the preemptor has transferred his entire share to the third party, my lord. And you lord.
have you served
Yes,
upon?
my lord. This is the executive of service. Translation, it was wrongly evident, my lord, upon. And it was returned with the remarks addressing left without instruction, my lord. Kindly see the evidence of service.
দেখি। So this is your application, petition, you are the petitioner.
I am the petitioner. Preemptee is the petitioner.
Yes. So it has now become infructuous.
Infructuous, my lord. The preemptor
Yes.
has lost his interest, my lord, since
Yes.
the transferred.
Assume. Affidavit of service is taken on record. Heard Miss Manali Bishesh, learned counsel for the petitioner, who submits under instruction that the preemptor, what is the name? Rajbihari Banerjee. Rajbihari Banerjee has sold and transferred his share in the property to, did you acquire or somebody else?
Yes, my lord.
It was acquired by you, sold to you.
No. Third party, my lord. On Pompa Mistro and the second one, Somnath Bhato. This is the
Oh,
application,
to-
7726.
To Miss Pompa Mistro and Somnath Ghatok. Stop. Therefore, according to Miss Bishesh, this revisional application has become infructuous and the petitioner does not want to proceed with the same. Stop. Under such circumstances, accepting the submission of Miss Bishesh, I am inclined to dispose of this revisional application as infructuous. Interim order of stay, if any, stands vacated. Yes. Pompa Mistro. দেখি একটা উনি কি বলছিলেন আইটেম নাম্বার 14 আদিত্য বাবু। Yes. What was your item?
My item, my lord, 14.
14, yes.
Taken up, my lord, after this.
No, not for the day. You have missed the train. Forget, come tomorrow. 31 may be taken up, I don't know.
26, Lordship will continue with this.
Yes, continue, perhaps there is no, there is specially fixed matter at 2. Second appeal, I have fixed 2 matters. Two specially fixed. So I don't know, you may try your hand.
Item number 24, if it is not taken up today, madam, may it be taken up on Tuesday, madam. I'll not be here.
Where is
madam.
your friend?
Yes, madam, he is for the petition.
And there is another,
Mr. Shomo. I will-
Somo Roy.
Yes, I will
Yes.
inform you.
ठीक है जी, 20
Tuesday.
one by one, please don't interject.
My lord, one in this matter. I have
Yes.
received opposition.
Item number 24,
Yes.
Tuesday.
Probably on Wednesday, because he is to,
I have received the objection by opposite number 1, 2, 3 yesterday. I want my journalist to file the rejoinder of this, the objection. If
Then-
1 week better.
देखिए मैडम मशरूम को 24 একটু এ করে দিন তো কল করে দিন দিন ফাইলটা দিন Mr. Chakraborty has been served with the affidavit in opposition yesterday only.
Yesterday.
একটা ম্যাটার জাজমেন্টকে গেল পঞ্চমপুরমে 8 তারিখে হয়েছিল বই আর আমরা দুটো বই দিলাম ছিল ওপেন কোর্টে অর্ডার হয়ে গেল এটা তো এখন এতেও এলো না এটা
Heard learned counsel for the parties, Mr. Chakraborty, learned counsel for the petitioner submits that affidavit in opposition was served upon him by opposite party number 2 and 3.
practically he filed a supplementary affidavit against that an objection was filed by the opposite party number 2 and 3. How that can be a reply, further reply can be used, I have no idea.
That is my lord's prerogative. Under indulgence, if it is allowed, I will file.
Then you will disclose.
I leave it out, your lord's my lord. I want to file.
Yes, it submits that a copy of affidavit in opposition to the supplementary affidavit filed by the petitioner was served upon him only on yesterday. Mr. Chakraborty wants to come back with rejoined. Having considered the objection raised by Mr. Bandopadhyay on behalf of OP number 6, I am inclined to accede to the request of Mr. Chakraborty. Accede to the request of Mr. Chakraborty. Let the matter be listed on
Other than Friday, my lord, next Thursday or Wednesday.
next Thursday means 24th.
I'll try, my lord. My branch manager has to come from Jalpaiguri. I'm trying my level best, if it is possible.
Then make it, my lord, Tuesday week, my lord. To be
Tuesday week.
To be on the safe side, my lord, again on the on that day, because only suffer.
Let me be very honest. From 28th onwards, I will not be here.
Let it be then 24th. Let him, my lord, try. Let it be on 24th.
But according, let the matter be listed on 24th of August.
But very next matter,
Under
lordship,
the same-
very next matter, very next matter, lordship.
Subject to my lord.
I shall take up all your matters after.
Very late, sir. I'm thinking, my lord, to fix matters. If I
Your,
miss
your,
the bus,
your,
if I
your
miss the
wristwatch
bus-
is running slow. Yes.
My lord, subject to the leave of the court.
And my lord, one matter, judgment, that was, my lord, in open court, my lord was pleased to dictate the order, my lord, on 8th. That is WBCTCL consumer related matter, my lord, consumer forum related matter. But
It has not been uploaded.
not yet.
I
I know, my lord,
WBACDCL and that Mr. Bhattacharya was there on the other side.
yes,
Yet to be consumer,
yes.
yet to be consumer.
yes.
But I have dictated.
Yes, very Bhattacharya was there. In open court, it was dictated.
Artisan. Oh, अच्छा, ठीक है. It will be uploaded. So.
My lord, and to books were there, Lord, I also, Lord, if I also kind.
ये नीचे. Mr. Nayak was there. He is representing WBCDCL. আপনি ওটা পাঠান আমি দেখছি. ওই রেকর্ডে দুটো বই দিয়েছে. Consumer Protection Act
And let's react on.
and the দিয়ে দিন.
My lord, subject to the leave of the court, my lord. My lord, subject to the leave of the item 31, we fixed on tomorrow at 10:30, my lord.
Hearing of application.
Application. Issue is order one will take.
Very
Yes.
well.
Tomorrow at 10:30, my lord.
Tomorrow at 10:30, I shall be here, hopefully. We'll meet.
We'll make a direction.
Yes. Where is your mobile phone? Bring out. See the time. Thank you.
My lord, let a direction be passed, my lord.
Yes, it will be in the list tomorrow. Thank
Tomorrow
you.
at 10:30, subject to the. Yeah. 10:30 থাকুন। Not. Operation. Lord, your lordship would kindly.
Yes.
Lord, your lordship may kindly recall the claims Lord did not. The plaint which was there, my lord, on record, and the plaint which I had, Lord, did not match. Lord, there was also an inspection report. There was an application, the order 41 rule 27.
LCA তে দিয়ে
পিছিয়ে বোঝাচ্ছ না কেন আমি ঠিক বুঝতে পারছি না।
The plaint.
হ্যাঁ বলেছিলাম আরেফিনকে একটা বাঞ্চ করে জজ সাহেবের জন্য এনে দিই, তাহলে রেকর্ডটা খুলতে হয়। অনেকবার করে বলি, একবার বলিনি। But it would be much.
It contaminates, Mr. Chatterjee.
The plaint আছে।
একটু জজ সাহেবকে দিই।
হ্যাঁ, এটা
পুরোনো পেনটা দিলে আবার
নতুন প্ল্যানটা
প্যারাগ্রাফ 3টা হচ্ছে মেন, এটা আবার পুরোনোটা আবার করে দিয়ে দিই।
না না
Problem is,
হ্যাঁ ঠিক আছে
problem is Lord, it becomes one's own matter, then it becomes even more. Lord, kindly look to Lord paragraph 3 on this, of the Lord, the compilation which I've given your lordship. Lord, your lordship may kindly recall the point which was being, Lord, urged by me here was, and what fell from your lordship was, Lord, I have, the onus was on me to show, Lord, that I was occupying another premises as a tenant. They said that I was the owner of that property. My lord was of the opinion, my lord, and absolutely, my lord, I bow down to your lordship. The onus was upon me to show, my lord, that I was a tenant. My lord,
You do not have any reasonably suitable accommodation elsewhere.
yes. So I had to show your lordship, my lord, that the occupation, my occupation in that premises was precarious. The word used, my lord, in the judgment is precarious. I am saying, my lord, before your lordship, that take it for granted, my lord, that my occupation there is not precarious. And then, my lord, your lordship goes on to see, my lord, whether that occupation in that premises was suitable, my lord, or whether I, being a lawyer, I have the right to, my lord, have my premises, have my, my lord, have my premises both as a residential as well as, my lord, my chamber. My lord, I will not trouble your lordship with everything. I just want your lordship, my lord, if your lordship may kindly permit me to show your lordship one judgment on this.
get the date. Before, my lord, because I wanted to canvass this point, my lord, and then I'll take your lordship to the, my lord, the kindly looks to the facts of this case. My lord, kindly straight away turns to paragraph 7. May I place it? where-
Yes.
The suit premises admittedly belongs to the deity, and the plaintiffs, being its Shebayat in terms of the deed of Orpurnama, are only entitled to enjoy a part of the suit premises. Rest is to be let out to fetch income for the deity. The suit flat falls in the said rest part. Therefore, the personal requirement of the plaintiffs cannot be equated with the requirement of the said deity, but the appeal court below has failed to appreciate this aspect of the matter, consequently has committed substantial error of law in equating the requirement of the plaintiffs with the requirement of the deity. The evidences on record, particularly the reports of the two commissioners, would demonstrate that the accommodation available to the plaintiffs in the suit premises is more than what they require. Kindly marks this. The findings of the appeal court below that the plaintiffs have been able to prove the requirement for the suit flat is based on no evidence. Rather, the said finding is contrary to the evidences on the record as such perverse. My lord, your lordship is not interested, my lord, with the next paragraph. It's on KMC. The plaintiff number 1 marks this. This is very important. The plaintiff number 1 has a flat at Bangur Avenue, Kolkata, but the plaintiffs, to project the artificial requirement for the suit flat, have suppressed the said fact. The said suppression affects the bona fide of the requirement of the plaintiffs. As such, the plaintiffs are not entitled to a degree of eviction on the ground of the bona fide requirement. In response to the above arguments, the learned counsel for the respondents submit as follows. My lord, your lordship need not trouble your lordship, my lord, with the entire. Kindly turns to paragraph 9. I have heard the learned counsel for the parties and have thoroughly perused the materials on record. Let me now proceed to deal with the formulated substantial questions of law. The defendant objected to the maintainability of the suit, alleging that the plaintiffs are the Shebayats. My lord, lordship need not trouble. Kindly turns to the second one. The suit premises has two parts. Lordship, a two-story building facing the Corporation Road is situated in the front portion of the suit premises, and the tile shed rooms are in the back of it. The learned trial judge, on the basis of the first commissioner's report, held that in the first floor of the said building, the plaintiffs have available accommodation, and on the basis of the other commissioner report, held that they have also available accommodation in the back portion of the said building. The appeal court below, on reassessment of the said two exhibits, opined that the available accommodation in the first floor of the said building is not sufficient to meet the requirements of the plaintiffs. Besides, the suit flat is the only suitable available accommodation for the plaintiff number 2 to run his chamber. This is also a lawyer's note. And it is also fit to be used as coaching class of his wife. The tile shed rooms at the rear part of the suit premises cannot substitute the said requirement of the plaintiff number 2 or his wife. The correctness of the reassessment of the said two exhibits need not be gone into, for the simple reason that the suit flat being situated in the ground floor and it is on the Corporation Road, therefore only available accommodation befitting for the said uses of the plaintiff number 2 or his wife. The law is well settled that the landlord has complete freedom in judging the requirement. The decision of the Honorable Supreme Court relied upon by Haldar such and such is an authority of the said proposition. The appeal court below therefore has rightly reversed the findings of the learned trial judge on this issue, and the findings of the appeal court below that the plaintiffs have been able to prove their bona fide requirement do not suffer from any perversity. It is based absolutely on the materials on record. The second formulated substantial question of law is therefore answered accordingly. My lord, your lordship need not trouble my lord self with the next one, because it deals with, my lord, there is a rent receipt thing that your lordship might, my lord, want to look into it. The plaintiffs have alleged that once Shri Praveen Jain is the tenant of the non-suit ground floor flat who has kept the said flat under lock and key. The plaintiffs to prove the said tenancy produced and proved the rent receipts issued to the said tenant, which were marked Exhibit 12 series in the said suit. In contrast, the defendant proved the exhibits E, F, and G, that is his applications to the defendant proved appropriate authority of the KMC under the Right to Information Act and the reply thereto. In the said reply, the names of the tenants recorded in the inspection book of the said premises were supplied, wherein the name of the said tenant of the non-suit ground floor flat did not find place. Now, your lordship need not trouble my lord self there, my lord. Can you seize the fourth substantial question of law? The plaintiffs are admittedly the Shebaites of the Debottar estate. The plaintiff number one may not reside regularly in the suit premises, but he deserves allocation in the suit building, at least of one room for his occasional visits. The availability of a flat far away from the suit premises neither can substitute the said requirement of the plaintiff number one, nor the non-disclosure of the availability of such accommodation can affect the bona fide of the requirement of the plaintiff. Lord, I am on that. Because my lord may remember, my lord, in this
we can circumnavigate within 10 kilometers of the
within
radius.
10 kilometers is, my lord, with respect to whether they have another accommodation within 10 kilometers. That is the problem. Lord, if I say, Lord, that I have a right to reside and my chamber, my lord, at the same particular premise.
There is no issue. Had there been any evidence to the effect that you were actually occupying the said premises, not as owner, but as tenant?
My lord, I am saying, I'm going a little further. I'm saying, my lord, take it for granted. Here is the case of ownership. Take it for granted, but never admitting, my lord, because I have an order 41 rule 27 where I have proved my tenancy there. I am not getting into that because I am a little, my lord, I have a hunch about demand. So that's why I'm not even getting into that.
No, while appreciating your aggression, I want to see the point.
Yes. Now, I'll take a look.
Did you take out any application for local inspection?
Yes. 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 There is a report. My lord, here in our case, my lord, I'll just, my lord, point out two things, sir. My lord, I am going a little ahead of what, my lord, is there in this matter. I am saying, my lord, that in our case, my case was tenancy, their case was ownership. Take it for granted, though not admitting, but for the sake of argument, that I am the owner, my lord, of that premises, whether it is suitable or not. Whether I, as my lord, the owner of the property, can choose where, my lord, I will.
No, absolutely, that is your prerogative.
So, my lord, I am saying before your lordship that forget, my lord, for the time being, forgets, my lord, I am a tenant. Takes it for granted, my lord, that I am the owner of that property. The High Court says, my lord, your lordship's coordinate bench, relying upon a Supreme Court, says the availability of something somewhere else. It doesn't talk about 10 kilometers. Because 10 kilometers, my lord, if I am not mistaken, my lord, is on the act. But that is for the tenant. That is for the tenant. Can we have a look at it?
Hey, premises tenancy.
अरे काकार मामला बोले कि বই আনতে নেই আছে Gives me 2 minutes time, not I will.
Can I lend you my book?
I'll get it.
Six D. Month.
Where the landlord or any person where the landlord or any person for whose benefit the premises is held reasonably requires the premises for his own occupation and the landlord or such person is not in possession of any suitable accommodation within the same municipal corporation or municipality or in any other area within 10 kilometers from such premises where this act extends. Kindly have a look at, this was an amendment which was made. May I read with your lordship once more? Where the landlord or any person for whose benefit the premises is held reasonably requires the premises for his own occupation and the landlord or such person is not in possession of any suitable accommodation within the same municipal corporation or municipality. My lord, this is not, if I am not mistaken, hey, or in any other area within 10 kilometers from such premises where this act extends. No, it has two parts. It has two parts. Reasonably requires the premises for his own accommodation and the landlord or such person is not in possession of any suitable accommodation. Yes. Within the same municipal corporation. Ours is corporation. Yes. Or municipality. Or in any other area within 10 kilometers from such premises where this act extends. Whether this is conjunctive or disjunctive.
You may interpret it in your own way.
Yes, my lord, because I was wondering this has come in, right, but did not give it a thought.
The question is, you did not take out any application to hold local inspection. So for the second accommodation is available with you.
Yes, my lord, we admitted it. We admitted it. Kindly have a look at my order 41 to 27 application.
Before the learned first appellate court, before your lordship.
जॉर्ज साहब के बात करेगा।
Hey, Adito,
Can number 7,
देखो तो
can number 7, can 7.
can 7. ওটা আমি বলেছি আমি অর্ডার করে দেবো বলছি করছি কিন্তু ক্যান 7 কোথায় আছে ক্যান 5 বুঝছেন ওকে দিয়ে আর কিনতে দিন let him find out
HON'BLE. Madam, can you got it?
Yes.
Lord, the first letter is to the officer in charge. Your lordship need not trouble, my lordship. C is 19. অদ্য হইতে উকিলবাবু আমাদের যে ভাড়া দিলেন তাহা হইতে একটি রুম ছাড়িয়া দিলেন. Because my lord, in that premises there was never my lord a rent receipt granted apart from one which is annex. ছাড়িয়া দিলেন উক্ত রুমে যে দরজাটি পশ্চিম দিকে আছে তাহা বন্ধ থাকার এবং উনি একখানি রুম তাহার চেম্বার ও একটি রান্নাঘর এই দুটি রুমে উহা নিজ ব্যবহারে থাকলেন ও বারান্দাতে টেবিল ও চেয়ার আছে তাহাতে থাকার নিজ থাকা ও তার নিজ ব্যবহারের জন্য ভাড়া বাবদ মাসে 333 টাকা পাওয়া. Rent is 333 and that is Kajam. Now, if your lordship turns over, my lord, your lordship will find the rent receipt. This is of course, my lord, in order 41, rule 27. This would show, my lord, with respect to the suitability. My lord, your lordship may, my lord, I completely bow down on that 10 kilometers, but the first word is suitable. Suitability and 10 kilometers probably doesn't, my lord, go hand in hand. The first thing is about suitability. So I am showing before your lordship.
Mr. Chatterjee, what I suggested to Mr. Harifin, the very first day, that you go, adduce evidence before the learned trial court, prove your tenancy, and get the decree. I don't know why, because additional evidence.
Because he suffered.
First of all, these are the photocopies. I cannot act on this. It is to be tendered and admitted into evidence. For that, you need to
25 years. That's what he says. Well, let me try on law.
He used to explain this to many other people also.
Well, let me try on law. If not possible, not your lordship would not. I will obviously cannot stand in the way. But I'll try and convince your lordship,
Yes.
Lord, with respect to my lord, whatever's on record. If my lord being the appellate court, if your lordship may exercise my lord's powers under order 41 rule 33, especially when my lord they are not even coming before your lordship. This is there is a bigger point, my lord, on this. My lord, your lordship's court was pleased to, my lord, appoint a special officer. Kindly have a look at that report once. Record the report. Point.
Mr. Chatterjee,
Madam?
why this local inspection report or report of the inspection commissioner, whatever it is, should be looked into? It was, even no notice was served upon the parties, there was clear violation of principle of natural justice. Only appellant was notified. You have not gone through any of the papers.
Inspection was happened. Kindly see, present.
Kindly see, read the copy.
Record. Order to the. May I once look at? Order about.
Yes, show me if I am wrong. Read the report.
Station officer is said. Notice was served.
Read the second page, you will get to know. Notice was served upon the appellant.
No, this I'll show. I'll take it. Again to Judge. Lord, can it turns to yes, and it turns to page 3.
3. Yes.
I entered the B schedule, second paragraph.
Hmm.
I entered the B schedule property. I found the B schedule property to be open and one person sitting on a new wooden chair and claimed himself to be a tenant. They were present.
Yes.
Tenant, but the said tenant could not show any rent bill. I also found some labor were engaged in cleaning
The
B
issue
schedule
is,
property.
Mr. Chatterjee,
They participated in the inspection. Even their Lord, I will show you, Lordship, not only the signature, but also Lord, their submissions have been recorded. Can he looks to Lord, my learned friend is Lord, the special officer, Lordship may even inquire from him. But in his report, he has written. Field note টা কোথায়? ওখানে আছে?
do you believe it is all right? As officer of the court. It cannot be, Mr. Chatterjee. Principle of natural justice must be maintained at any cost.
May I once look into the field note?
Yes. This is the fundamental thing. Mr. Arifin the junior, why don't you engage someone to assist Mr. Chatterjee? You are emotionally charged. You will not be able to discharge your duty.
Kindly Willard looks to the order of 8th of April.
8th of April.
I completely agree.
Then 8th of April.
8th of April. The order, Malakani got.
Yes.
The order passed on 26th of June 2019 by the Registrar Administration reflects that a notice of appeal addressed to respondent numbers 1A, B, C, and 2 has duly been served on 31st March 2019. That apart, the report of the process server shows that the son of respondent number 2 has received the notice on behalf of respondent number 2. It further reveals that notice of appeal upon the respondent number 1B has been completed as he has received the same. The respondent number 1B has received the postal notice on behalf of his mother Onupa Shingho, as it is evident from the cost title of the application order for 5 Rule 20. As such, it has been reported by Registrar Administration that there appears no impediment to hold that the notice of appeal addressed to respondent numbers 1A and B have been duly served. It also appears from the office report with India Post Consignment Tracking Report that notice of appeal addressed to respondent number 1C has been duly delivered on 4/4/2019. Thus, the process of service of notice of appeal upon the respondents have been completed, but in spite of service, none has appeared. Under the circumstances, the application being such and such is taken up for hearing and consideration. So, my lord, audio alternate patent, my lord, is taken care of by the honorable judge.
No, no, no.
And then-
I am not on notice to appeal.
Then, my lord, he served my learned friend, served notice on the other side. Those are the ones which your lordship will find, my lord, as an annexure. These are the ones here. And thereafter, my lord, the reports were all there. The tracking report is all there. And that he sent, my lord, by speed post, your lordship will also find, my lord, he's annexed that to the report as well. And there is a field report where, my lord, সই করেছে কোথায়? And Amitabh Sinha, my lord, he has signed.
Who is Amitabh Sinha?
Amitabh Sinha is their lawyer. No, lawyer is Rahul Singh. The party is Amitabh Sinha. He is, my lord, respondent number কত বলে যাচ্ছে? Respondent number 2. He has signed on the field report.
What is the B schedule property?
Yes, B schedule property, my lord, he has given is under lock and key or not. That is what the honorable judge wanted to see, my lord.
No, what is B schedule property?
I'll show you. Kindly looks to the field report once.
Then
They have signed it. So, কোথায় গেল? Plainটা. Plain. Three bedrooms, one kitchen, one bathroom, and one privy, and garden in the ground floor of A schedule premises.
A schedule premises is a suit property.
Yes.
B schedule is part of that.
Part of A, B is part of A.
A. We are on the tenanted premises.
On the
at
tenanted
Khanpara.
premises. Look, here he was sent to see whether they've kept it under lock and key or not, and for how long. Because that's also a ground below on the premises sense. And this report shows, below, that they had kept it under lock and key for quite some time. And below, I just need to place it. Kindly it looks to, from the second page, may I place for your lordship's kind consideration. My lord is looking into the report, below.
Yes, you carry on.
Looks to, below, the second, from the second page. That I was served with a copy of the application for local inspection, judgment and degree passed
Yes,
by
yes.
lordship. Second page. Then kindly comes down. In compliance with the order passed by the Honorable High Court, I have come for physical verification and or inspection on scheduled date and time being 26 July 2021 at 3:45 PM at A schedule property, being all that rooms including ground floor and first floor in plot number such and such, the address. That A schedule property I found Mr. Syed Jaimul Abedin brother, representative of Syed Shamsul Arifin, the appellant hearing, and Mr. Amitabh Sinha. The respondent number 1B appearing on his behalf and submits he appearing on behalf of all the opposite parties. My lord finds that. Accordingly, I entered the schedule A and B property. The schedule A and B properties are identified by both the parties. That A schedule property is all that rooms including ground floor and first floor in plot number 223 appertaining to Khotian number such and such, known as such and such. And B schedule properties is the 3 bedrooms. I entered the B schedule property. I found the B schedule property to be open and one person sitting on a new wooden chair and claimed himself to be a tenant. But the said tenant could not show any rent bill. I also found some labor were engaged in cleaning B schedule property. The representative of the plaintiff states that the property were opened yesterday, and since yesterday it is open and previously for more than 10 years, it was under lock and key. As the opposite party number 2 have bought a new house way back, and the opposite party number 2 along with his family resided in their new house. The opposite party number 2 denies the above submission of the representative of the plaintiff and states that the B schedule property is always open, and opposite party number 2 along with his family is residing there since long. So they have even made submissions. Then I found B schedule property not to be used for a considerable time. That's his
Opinion.
assessment.
Fine.
Because that's what
Now he is assuming the role of an expert.
assuming the well, I'll just allow me to read.
Yes, absolutely.
I found water seeping through walls and waterlogging problems in the B schedule property.
Yes.
I found bathroom to be redundant and incapable of being used by any person, and in fact, it was not used at all. Lord, if your lordship goes, Lord, it's probably, my lord, not a role of an expert. My lord, with a naked eye, if your lordship goes to any place and sees whether it's inhabited or not.
Fine.
He's given reasons for that, and there is no challenge to this. My lord, he has put in this report way back. There is no challenge to this report at all. Then I found damp on all the walls. I found that the garden to be unkept and not cleaned and maintained condition. I found logs of timber along with the building materials kept concealed with a bed sheet against one of the wall of the bedroom located in the eastern side of the B schedule property. I found cracks on the walls, pillars, beams, and roof of the kitchen, bedrooms of B schedule property. I found the building to be very old and in a dilapidated condition. I found walls peeling off from ceiling, pillars and roofs. I found bare iron rods exposed to the naked eye on ceiling of the kitchen. I found water seeping through walls and waterlogging problems in the A schedule property. I found bathroom to be redundant and not used at all. I found dirt and small wooden plank lying in the sanitary ware. I found doors of the bathroom to be rotten. I found damp on the walls. The representative of the plaintiff submitted that the B schedule property was under lock and key for more than 10 years. The opposite party denies and submits that the opposite party had been residing in the property for long. On inquiry from the adjacent shop owners, I came to learn that B schedule property was under lock and key for many years.
Fishing out of evidence is permissible.
Beloved, it has been done, has been allowed. This is done on the basis of a high court order.
Yes.
And without a challenge to the same. It's on record, my lord. It cannot be in today, my lord, deleted. It's on record. Whether this is fishing out of evidence or whether this is the best evidence.
I'm seeking your opinion, whether this is fishing out of
respectfully
evidence.
submitting no.
No.
Once the High Court has allowed it.
That is a different thing.
My lord, I am on that. I am on something which is there on record. My lord, I am not today coming before your lordship, my lord, with an evidence. But it's on record.
Yes.
High Court has allowed it, has gone, my lord, unchallenged. So this is evidence on record. My lord, if they had come and challenged this before your lordship, there was a different story altogether. I would have, my lord, probably conceded. But now, my lord, that the court goes unchallenged. My lord, this is evidence on record.
Yes.
And, my lord, credible evidence. Because why? It's supported by, my lord, an order of the High Court. The High Court wanted him to do this. If the court has, my lord, wanted something to do on its own, it can, my lord, under Order 47, Rule 41, Rule 27, Rule BB, if I'm not mistaken. The court can. And once the High Court has embarked in this journey, my lord, in my respectful submission, this is a part of evidence. If at that point of time, my lord, there was some opposition, and even an opposition to this, my lord, evidence, I would have understood. This is going unchallenged.
When the order was passed, 18th of April.
Passed on. I'll give you a lordship. 19th of July, 2021. looks to the my lord, the order once, and for your lordship's own my lord conscience, kindly satisfy my lord's own self.
Just give me a minute.
এটা তো জজ সাহেবের কপিটা আমার কাছে নেই। ওই অ্যানেক্সচার গুলো আমার খপ্পরে আসেনি। তো এতদিন ধরে 2 বছর ধরে চাইতে পারতে। আমি যেটা পড়ছিলাম সেটা জজ সাহেবের কপি থেকে পড়ছিলাম। Lord, in the second or the third page, my lord, after my lord, the taking into consideration, the Justice Prasad had my lord formulated the points. Second or third page of the order.
This inspection was held under the order of Justice
Justice
Prasad.
Prasad. Justice Prasad.
Did you take this ground?
Allowed by the High Court. Lord, I'm talking from anything, Lord, which is on record. Lord, your lordship knows. Lord, in
The
a,
judge is not supposed to know anything.
my lord knows everything. It's just the lawyers will not remind your lordship, and every time teaches the Lord, the people in front. Lord, your lordship knows, suit for eviction, if any of the grounds approved, any one of the grounds approved by cogent evidence, my lord, that's sufficient.
No, there has to have some pleading.
Lord, that
Somewhere.
is not being used, there is a pleading, if I'm not mistaken. I'll give you a lordship.
Mr. Chatterjee, come to page 3 of order dated 8th of April 2021. Say,
My lord,
down the line, say 10 line, you leave 10 lines. It is further pointed out.
yes, my lord,
Have you got it?
has kept the B schedule property under lock and key.
Huh.
And whereas the petitioner's son has purchased another house in Burdwan, and the opposite party with their family members are staying in that house. The petitioner's son means
Who is
my lord,
petitioner's son?
the other side, because actually the defendant's son.
Petitioner is the
Defendant.
defendant. Defendant didn't
That was a
appear.
wrong, my lord. That was a wrong thing. That's a wrong.
Then again, it is the record of honorable court only.
Lord, your lordship would correct it. This is on face of it, my lord. It's a typographical error. 152, my lord, your lordship would
No.
not.
No, this is
invoke.
not clerical mistake.
Typographical. But that's our case. I'll show you, your lordship. Pleadings are there. And whereas the petitioner's son, that should be the defendant's son, the opposite party with their family members are staying in that house. The Schedule B property is lying vacant since last 16 years under the possession of the defendant who have closed all doors and windows of B Schedule property. It is also submitted that condition of B Schedule property is in dilapidated and shabby condition. Accordingly, an inspection has been sought for, finding no contrary contention on the part of the opposite party as they have not entered appearance despite notice of appeal. And upon hearing the learned advocate for the petitioner, the prayer as made in the application is considered and is allowed. Advocate such and such be appointed
No,
the learned
Did
inspection
you,
commission.
did you take this point? This is one of the grounds for eviction perhaps.
Yes, it's a one of the grounds for eviction, my lord. It's not there per se, my lord, in the plain. It's not there per se in the plain.
Then why should we embark upon
My lord,
that?
again, under order 41, rule 27, my lord, I have brought out an evidence. I want his eviction. My lord, is it necessary, may I ask this question to myself, to actually, my lord, put forward in the plain why I need an eviction? My lord, I am there, I am seeking, my lord, his eviction on certain grounds.
What are the grounds?
The grounds are reasonable requirement and evidence I have laid that he has kept it under lock and key, my lord, for quite some.
No, you cannot lead evidence without pleadings. That is the foundation.
My lord, there is,
Please,
there
Mr.
are,
Chairman.
I'll tell your lordship, my lord, there are 2 to 3 decisions on this. Your lordship knows better than me. In, my lord, while proving reasonable requirement, I don't have to prove everything. I don't have to give, my lord, the why I need them.
No, not at all. I am
don't
not
have-
asking even that.
My lord, I am saying,
My
if you're, I bow down, I'm completely bowed down. But I'm trying to, my lord, your lordship knows I'm in a tricky situation. What I am trying to put forward before your lordship is on the basis of the evidence on record which has come up in
Now-
the appellate court.
Now tell me, is it permissible to adduce evidence beyond pleading?
My lord, strictly speaking, no. I cannot say yes, but there are exceptions. There are exceptions. And the exceptions are, in my respectful submission, something like this. Something which has cropped up in evidence, which will lead to, my lord, the root of the crime. I have pleaded. It's
Yes.
not that it's not there in the pleadings. My lord, I'll show you a lot
In such a situation, this statement or the evidence would have come or the fact would have recorded in course of cross
I'll
examination.
tell you, lordship. All this was, my lord, I
But
completely
as
bound.
plaintiff, you cannot lead that evidence going beyond your pleading.
If the court allows me to lead it, if the court has allowed me to lead it, when there is no objection from the other side, I'm entitled to take advantage of that. I'm entitled to take.
And the court reserves the right to ignore that part, which is beyond
Because
pleading.
once the court has taken it into evidence, the evidence cannot be ignored. My respectful submission before your lordship. Your lordship will take a totalitarian view of the matter. My lord, in my respectful submission, it is not for the court.
So are you going to abandon the requirement part?
I'm not going to abandon anything. I will try and convince your lordship, my lord, even without a pleading to that effect, my lord, if the evidence is there, my lord is entitled to, my lord, grant eviction. My lord, have a look at the photographs.
Should I engage Mr. Banerjee as amicus to
I have
counter
no
you?
problems.
To
Kindly.
counter
Yes.
you?
Yes, because then it will not go, my lord, undefended again. And Mr. Banerjee is always in my side, my lord, there is no
Yes.
problems at all. My lord, kindly turns to, I'll take your lordship to the supplementary affidavit which
No,
was filed.
what prevents Mr. Arifin to get the matter done through trial court? What's the
they've waited
problem?
for-
I really fail to
They've
understand.
waited for 25 years. Especially, can you have a look at the photographs once? At second. Acha daro, theek hai.
I am asking to you through Mr. Chatterjee.
You are now the client, you cannot talk. You should not talk. My lord, kindly have a look at the photographs once your lordship will, my lord, find it. That the house is being wasted.
Photographs.
Photographs lo babu.
Exhibit.
No, it's there with the reports.
Report.
And also I have filed, my lord, and file in a supplementary
Come on,
affidavit.
don't insist me to write evidence act, please. It's beyond my competence.
No, that I cannot see. Not beyond your lordship's competence, but it's beyond my lord's comprehension in this matter. ছবিগুলো দাও। হ্যাঁ? জীবন ফাইল করতে দেয়নি? জীবন ফাইল করতে দেয়নি। একটু জজ সাহেবকে দেখাও, একটু জজ সাহেব। Kindly sees this is the, my lord, the.
How it
position-
will help you? I cannot take it into evidence.
I'm
I
just
cannot
trying
read
to-
it into evidence.
Just trying to prejudice my lord. Openly. This is the way the property is. Lord, why I tell your lordship, Lord, with this is,
Even you don't take care of this property. They are the owners.
yeah, they are not there, my lord, in the ground floor, they can't go. Ground floor, they can't go. They can go directly, my lord, if they want to, but they don't, they cannot. Till there is a degree for eviction.
No, no. Is this vacant portion is within the tenanted?
Within the tenanted portion. And that's B schedule, my lord. Lordship sees.
Who drafted the plant? You?
3 bedrooms, 1 na tokono jonmai. 3 bedrooms, 1 kitchen, 1 bathroom, and 1 privy and garden on the ground floor. That's B schedule. Plaint was not filed in when? এটা সে মারা গেছে, যে উকিল বাবু মারা গেছে, কি নাম বললেন? প্রশান্ত শাহ. My lord was there in Mendipur, বর্ধমান, I'm sorry.
No.
প্রশান্ত শাহ. Now, let me, my lord, try to convince your lordship with certain things which are there on record before getting your lordship into, my lord, the some things which are not, my lord, in
Yes.
record. Kindly turns to, my lord, the plaint ones.
Plant.
After I fail, my lord, something from here, I will go, my lord, to something which is not there, my lord, which is on record, which is not on record. But I think I can convince your lordship with the, my lord, the evidence which is on record. Kindly looks to, my lord, paragraph 2. That as the defendant was a monthly tenant, under the previous owner Amanullah, the vendor of the plaintiffs had a monthly rental of rupees 95 according to English calendar month, and the same, Malakali got it. At on, the plaintiffs used to take monthly rent at the previous rate of monthly rent of 95 only, but he is a recalcitrant tenant causing various nuisances in the tenanted rooms, and his behavior is very much vexatious. That the first floor of the suit premises is being used by the plaintiffs number 1 and 2 jointly for their own residential purpose. Marks this. This is where I'm on now getting into things, my lord, which are on record and not trying on something, my lord, which is on the periphery.
Yes.
With much hardship and difficulties, along with the married brother of the plaintiff number 1, namely Syed Joinal Abedi, a pathologist, marks it, and the daughter of a younger brother of the plaintiff number 2, who due to poverty of her parents since her childhood staying with the plaintiff number 2 and maintained by the plaintiff number 2, and at present she is studying as a higher secondary examiner. That apart, a nephew of plaintiff number 2, namely Habib Ahmed, maintained by the plaintiff number 2, a student of Borhat Ramakrishna School, Burdwan, are all staying on the first floor of Schedule A premises in a joint mess. And the accommodation of all those members on the first floor of the Schedule A premises is not at all enough and sufficient, rather over congested and too crowded to live comfortably, and due to such acute scarcity, shortage of accommodation, the wife of the plaintiff number 2, along with her son, has been compelled to live at her paternal house in Calcutta. That is, in the house of the father-in-law of the plaintiff number 2 as a license. This is on record. Be it mentioned here that the plaintiff number 1 is an advocate practicing in the Honorable High Court at Calcutta, and as he has good number of clients at Burdwan, for which the plaintiff number 1 is in urgent need of a chamber in the ground floor, marks that. This is what I'm, my lord, why I showed that judgment, my lord, of Justice Basu. Of the Schedule A premises to receive and to deal his clients there, without which the profession of any practicing advocate is liable to be hampered badly, and that is why the plaintiff number 1 had to take shelter near CMS School, Burdwan, at a rental of rupees 333 per month as his chamber under compelling circumstances. Now, this part Lord, is now proved in that order 41 rule 27 application. Your lordship said that your lordship cannot look into it because it's a photocopy. Now, my lord, I say that since it's unchallenged and since, my lord, I can lead secondary evidence, and if your lordship wants, we can produce the originals as well. If your lordship wants, your lordship may take that on record as secondary evidence in support of whatever is already there on record.
No, the question is while deciding a second appeal, can I record evidence?
My lord, order 41, rule 33.
Order 41,
Rule 33.
rule 33.
If I am not mistaken, kindly corrects me if I am wrong. And even Mr. Banerjee can be, my lord, amicus curiae. I have got no problem. The appellate court shall have power to pass any degree and make any order which ought to have been passed or made, and to pass or make such further or other degree or order as the case may require, and this power may be exercised by the court notwithstanding that the appeal is as to part only of the degree and may be exercised in favor of all or any of the respondents or parties, although such respondents or parties may not have filed any appeal or objection, and may, where there have been degrees in cross suits or where two or more degrees are passed in one suit, be exercised in respect of all or any of the degrees, although an appeal may not have been filed against such degrees, provided that the appeal court shall not make any order under section 35A in pursuance of any objection on which the court from whose degree the appeal is preferred has omitted or refused to make such order. So order 41 rule 33 is a power given to the appellate court, my lord, similar to that of the trial court. My lord, in second appeal, even a 17-2 application was filed. That's a reported judgment, my lord. This was a very highly contested matter. If this can be done, Mr. Shudis Dashgupta, my lord, was the lawyer at that point of time who argued this, that even post-suit defaults, even during pendency of a second appeal, a 17-2 can be brought. So evidence, blood pleading is there. Evidence unchallenged. Blood, they could have come up before your lordship. Kindly sees their attitude. They could have come up before your lordship, challenged it. That look here, this is not correct. This is not true. They have chosen.
Does it mean court can trample over the
not at all.
rules?
Court has to satisfy its own self. I bow down. But if it is on record, and this is only a supplemental of something which is on record, then my lord, order 41 rule 33 comes into play. I am not for a second saying, my lord, that I will get a degree because of non-travel.
Once again, look to section 103.
Yes,
there is restriction imposed upon the court while deciding any second appeal.
Yes, my lord. Kindly looks to 103.
Yes.
If any second appeal, the High Court may, if the evidence on record is sufficient, determine any issue necessary for the disposal of the appeal, which has not been determined by the lower appellate court. That's the other ground. Appellate court, or both by the court of first instance and the first appellate and the lower appellate.
Yes.
Or which has been wrongly determined by such court or courts by reason of a decision on such question of law as is referred to in section 1.
No,
this gives your lordship power.
Mr. Chatterjee, power is restricted to certain terms and conditions. Now, you are inviting the court to admit evidence by way of additional evidence and to decide the appeal.
My lord, I am, in my respectful submission, admission part is over. Justice Prasad.
No, I'm talking about your additional evidence.
Order 41 rule 27.
Order 41 rule 27.
Yes. My lord, I am on. My lord, technicalities is the handmaid of justice. If your lordship finds, my lord, I have the originals with me. I have it. 25 years has gone, my lord, in litigation. If it's a technical point, my lord, your lordship may very well, my lord, allow, my lord, adducing evidence even at the second appellate stage. There is no bar under the act, under the code, that your lordship cannot. And I'm making a bold submission before your lordship.
In one sense, if we look at order 42, we can find something out of that.
Order 42, my lord, might be a little different. But if your lordship sees, there is nothing on record here which bars your lordship. On the contrary, my lord, order 41, rule 27 is an allowing provision. If your kindly sees, BB, AA rather. I'm sorry.
Yes.
B. The appellate court requires any document to be produced or any witness to be examined. Marks it. To enable it to pronounce judgment or for any other substantial cause. This is court's requirement.
But
this is an enabling provision. Respectfully, sir. Kindly takes order 41 rule 27B and order 41 rule 33 together. Clubs it, your lordship has power. Lord, I'm not saying your lordship will exercise its powers in every matter. I'm not saying so. The ambit of order 41 rule 27 Lord has to be looked in. Lord, there is a judgment. I don't have it offhand. Lord, to be very frank before your lordship, in my small stint here, I haven't seen evidence being led in that manner, my lord, or I would say, my lord, a witness coming and giving witness.
Which is why I was suggesting that let Mr. Arifin appear before the learned trial court.
My lord, I am. If your lordship sees, my lord, it's whether your lordship has powers or whether your lordship doesn't want to exercise those powers. I am showing your lordship, my lord, that your lordship has the power. My lord, here I am not even saying that your lordship will ask a witness to come and, my lord, give evidence. It's a document, my lord, which needs to be produced. I have my lord, the originals with me here. Now, what is a remand? My lord, your lordship goes back to the judgment of Justice Rankin, 33 CW. Appellate court cannot brush aside its responsibility. That's the only judgment, my lord, relied upon by any court while, my lord, dealing with an order of remand. My lord, if your lordship has the powers, may I ask this question to myself, my lord, why not exercise it? Sees my lord, the condition of the property, sees the condition of the litigant. In this case, your lordship even can see that. And exercise the powers for justice.
Had the documents been public document, I would have.
Public document, my lord, definitely. I bow down.
I would have admitted.
I do not for a
now
second.
The difficulty is it requires to be proved under the law.
My lord, if I say, my lord, if a document which is not objective.
No. Then again, responsibility then double.
My lord,
I have to take care of the interest of the defendant.
Takes care of the interest of the defendant. Takes care of that. I will not make submissions for it. Takes care of that. I will on my own, my lord, make submissions for it. To show your lordship, my lord, how justice needs to be subserved. Now, I'll come to this again. My lord, this is only under order 41 rule 27. If I can satisfy your lordship that from the evidence which is on record, I'm entitled to a deed. No. My lord, what
else we can do one thing.
Yes.
We can send it back before the learned appellate court to record the evidence, to record the evidence on this additional evidence
just-
and send it back to this court for consideration. That can always be done.
within 15 days.
15 days, hardly a month.
Acha, Lord, I will keep this in mind. But even then, I will try and.
It
do
will
a
not be an open remand.
Limited remand. just
Limited
for that,
remand, yes.
Just for that.
Only to consider those documents and to
And
send
to
it.
send it. I bow down. Lord, I will definitely will not, I bow down to your lordship. But if I can convince your lordship, Lord,
Yes.
that on the basis of whatever is there, I'm entitled.
Okay.
That's why I started off by saying, Lord, ground floor
Yes.
and that judgment. Kindly it turns to now. Paragraph 5. Lord, only one thing, kindly do not keep it tomorrow. Tomorrow I have to go to Lord Mednik.
Very good.
Lawyers, one of our colleagues, Lord, his divorce. I have to ask you on that.
Why they are contesting?
They're not.
He's an advocate. Then
He's not. He wants it. The other side doesn't want to give. And tomorrow, my lord, the Supreme Court has said that it has to be disposed of within the month of August. And I haven't been able to, my lord, travel at all these days. So I gave him word that I will do it on Friday.
so finish it today itself. Oh,
Today
we
it
have
will be a
been late.
little, I know, my lord, it will be a little because I have to take your lordship to the evidence. I know I will not be able to finish it because if it was till 4:30, I could have. But today
Oh,
there's
today is
3:30.
3:30, no?
3:30. So I'll take your lordship till 3:30. Then kindly keeps it on Monday at 2 p.m.
Monday
After
at
I finish.
10:30.
At 2 p.m.
At 2 p.m.
2 p.m.
Very good. Should we stop here or you want to
I'll
proceed?
do it
further?
on Monday.
But consider that
Lord,
aspect
I
of
will keep
limited
that
remand.
definitely in mind. Definitely.
Madam,
In any other matter, my lord, I would not have troubled your lordship, but she's my predicament as well.
in- Hard
Lord,
Mr.
may
Chatterjee.
I pray for this, and I pray for this before your lordship so that it is complied with. Plain, I'll make a bunch of a plain written statement and the evidence so that, my lord, I don't have to go from here to there to everywhere. Like a paper book, I will take the weekend and I will, my lord, get to your lordship so that even my lord doesn't have to, my lord, get into it. It's a request to your lordship.
Hard Mr. Chatterjee, learned counsel for the appellant. Let the matter be listed on 21st of August. Aditya Babu, সোমবারে আমাদের কি আছে? কিছু আছে স্পেশালি ফিক্সড এরকম কিছু?
Then Tuesday. So Monday হবে?
হবে? 21st of August as item number 1. এটা করে শেষ করে দেব। Monday we will close this matter.
সকালে 2 p.m.
2 p.m.
2 p.m.
Okay, at 2 p.m. You are late riser? এটা দিয়ে দিন।
I was not late. I lost here.
You keep it with you
But
on the agenda.
I argued what the other side would have argued before your lordship, but I lost here. And here, my lord, the facts were that they had kept it under lock and key, the landlord. The High Court said that even then that's not true. There are thousands of judgments I showed, my lord, that suppression. And if there is suppression, that it's not bona fide. But the courts today, my lord, are hardly like your lordship, lord. The tenants have got no rights at all. But I've said a tenant and a husband have got no rights in this world before a court of law.
But you are fighting for the tenant as well.
I am, beloved. That's why
And
I've chosen this profession.
You have burdened me. No, you have burdened me to safeguard the interest of the tenant as well.
I have not. They chose not to appeal. The other side did not choose to appeal.
Now you just help me in one matter. Yes, you come. Yes, sir, I am. Tell me. What else?
Oh, my lord.
Your lordship, with regard to item number 50,
No,
that was
in the,
passed to-
no, no, my lord.
Have
Item
you
number-
finished your point?
Yes, my lord.
What is the election?
My lord, it will be stamped properly.
Now, Mr. Chatterjee, as officer of court, one tenant surrendered tenancy in favor of the landlord, and there was development. Landlord and promoter, or the owners, both the owners, entered into an agreement with the tenant, promising him a flat, say around 800 square feet or something, free of cost. And that gentleman filed the suit for specific performance of contract. Trial court refused to admit the agreement on the ground that not properly stamped. Now the consideration money is zero, free of cost. How they could assess stamp duty like conveyance? So I suggested one thing. I am going to reverse the order. Stamp duty is not applicable.
Yes.
But it will ensure your defeat. You will never be able to acquire the title over the property. But as on the ground of rebuilding, you can claim the possession.
Yes.
Now,
Whether he's agreeable to that.
I gave him time to elect what to do.
না হ্যাঁ তারপর তোমাকে এডিট করে দেবে
হ্যাঁ আমি proper stamp দিয়ে দিই।
Stamp, how to assess the stamp?
But this will depend on, I don't know the facts of it, will depend on that agreement which was entered in.
Free of cost.
Free of cost, yes, but stamp is on the government value.
Government value, on the market value.
So you take the circle rate or whatever
Yes.
is available.
Yes. And that will not safeguard his rights. from the-
So I shall direct the learned trial court to assess the value, though it is free of cost at the circle rate.
No,
You
the
will
law
pay.
Law is now that.
Yes.
Because today, if your lordship goes to register, whatever be the contractual value, it will be on the circle rate.
And it is to be impounded, mind you.
10 times. It doesn't have a option.
And it is in Shiliguri,
In Jalpaiguri.
Jalpaiguri.
Far from
10
Jalpaiguri.
times.
10 times, that's Supreme Court has now said that it's mandatory.
So I am disposing it off in that way.
Otherwise, my should goes.
Ah,
I have told you, I can ensure defeat if you want short-term gain.
Well, regarding item number 15, I am the respondent and my learned
15.
is
Yes.
appellate. We are both paying for not this week. or
Not
better-
this week.
Kindly take
Or-
it up on Tuesday and.
Somehow manage tomorrow, you will get not this week.
My lord, the paper book is ready. There was direction to
The
prepare and
paper book.
file the paper book.
So you file it in the department,
The direction was to file it.
in the court, file it. No. You are the
I am
respondent.
for the respondent.
It's for the applicant.
Yes, I am
for
for
the
the appellate. It is for the respondent.
Okay. So appeal is otherwise ready. It will be taken up in the month of September.
Lordship, Tuesday, my lord, it was fixed
No,
for hearing
No,
today.
I have heard already considerable number of appeals. It's very difficult to find out time. Then I will not be here from 28th to 11th of, till 10th of September, Jalpaiguri. Then I have to come back and manage everything.
Sir, needed-
I have to carry everything to Jalpaiguri. All those matters I have already heard.
was there yesterday. Nice one.
You should visit there. You should visit circuit bench.
When they, Whoever takes me the poor lawyer, I have to 30
Then-
bench, 12 bench.
Then your juniors are good for nothing.
My lord, may I order be recorded with regard to the filing of the paper book and also my lord.
Madam, একটু আসুন তো। Item number 15. Hard learned counsel for the parties. One copy of paper book is submitted in court. Copy of paper book has been submitted in court. Let it be taken on record. Let the matter be listed for hearing on 13th of September.
Not with regard to item number 12.
12. We are on 15. Don't ask me to put the cart on
No,
the
no,
reverse
no.
gear.
That
Yes.
is right, my lord, your lordship. Lord, maybe please to fix it on 23rd.
2 p.m.
Yes.
No, I don't mind. If you can ask.
I'm not insisting, my lord.
No, no.
We are 23rd, my lord. Both of us have agreed at
23rd.
23rd at 2 p.m.
23rd.
28th.
Hopefully 25th. 23rd.
23rd.
Who is your other side?
Yes. My lord.
Oh, that matter.
That matter. That envelope not open.
No, yes. That is a mistake committed by Lord Trial Court. I have requested for a report. Let it come.
Lord, that is not a mistake for the appellate.
No, what happened? This gentleman, the
Appellate
presiding judge,
Trial court, my lord.
no, presiding judge did not put his signature after the evidence. He came back.
Lord, it was not tendered.
No,
This is
I do agree with you. It was not tendered. He came back after 1.5 years. He just kept on lending his signature over the documents placed before him. He could not remember what happened actually when the evidence was recorded.
Lord, I can satisfy your lordship from the record.
It was never tendered.
That document was not filed with Christie. From the Christie document, I said.
That I cannot say, but
No, that I will refer it to your lordship. Thereafter, in the middle of this was filed. Anyway, my lord, at that time, I will argue before your lordship.
no,
There is
notice
mistake on the part of the trial court.
notice was issued by the court. So it will come back to court. It will come back to court. It is supposed to be with the record.
Lord, unless that, no, not court.
series.
Lord, that was not issued by court. That was issued by a lawyer. That is rejectment notice.
Oh, it is
a
not
court-
summoned.
court
Yes.
document.
Lord, you are the plaintiff.
I am the defendant.
You are the
I
defendant.
am the defendant.
Okay, let the report come. If I can give some respite to you, I will see to it.
কারোর ফেভারে নয় আইন যার ফেভারে সেই হবে
No, the difficulty,
আইন যার ফেভারে তার হবে
let the report come on 20, এটা আজকে registered judicial petition. ওই ডিপার্টমেন্টে কালকে এসেছিল যেতে পারে
না, না,
আন্দামানে যাবে।
থাক না।
That man is. Yes, sir.
Then 23rd my lord at 2 p.m. let it
At 2.
be mentioned.
Shall come back at.
Thank you. Yes. Huh? But just give me a minute. Just give me a minute. Could you finish up the argument if it is taken up at 2?
Yes.
Who will assist the court? You or Mr. Chatterjee?
Lord, because only one point, one formulated point I argued. Other points are there. I shall have to argue on other points also.
You don't appear before a bench dealing with bail application.
No, my lord.
No.
He does, of course. কি তুমি বেল করেছো? হ্যাঁ
seldom,
করেছে করেছে
Very
আমি
seldom.
বলছি
very seldom.
right now was no straight on the face এই আমি ছিলাম বলে আমি জানি বলে
Not very seldom.
No, then we can take up the matter at 10:30
Yes.
in the morning, because 2 to 3:30, it's very difficult.
not necessarily there will be a future
23rd is, no, thankfully not Friday.
not a Friday basically
Anyway. Very well, you come back on 23rd at 2.
So, perhaps I said, April. I think.
Item number 34, plaintiff petitioner in person. What is the issue? Thank you. What is the issue? Declaration permanent injunction, then why did you approach the court? Which application? Revisional application? It's for restoration.
Restoration and.
There is a precondition. You need to satisfy me on the merit of the application. Then only I shall spend my time, otherwise it will never be restored. So come prepared. I don't know, it will be in the list if I can reach. But you need to address me on the merit of the petition. It will not be restored simply on your prayer. I shall look into the merit of the matter. If I find there is merit, then only it will be restored, otherwise not.
Lordship, if I may break for one indulgence, Lordship, item number 30, Mr. Gupta is for the opposite party. On the last occasion, your Lordship directed us to serve and inform the petitioner and that put on record that this will be appearing today. But your Lordship, Mr. Gupta is not keeping well. I was praying that it will be taken up after Wednesday.
Very well. Okay, you come tomorrow. You come tomorrow. We'll see.
Gratefully, Lordship.
Thank you.